court is open. Please be seated.
Good morning and welcome to the Appeals Court. We are continuing our session. We heard the first case this morning using our Zoom remote hearing platform. I will reintroduce the panel. I'm Chief Justice Mark Green. To my right and your left is Justice Amy Blake. To my left and your right is Justice Vicki Henry. We will be the panel on the remaining 5 cases that we have on for hearing. We've read the briefs. We're familiar with the arguments that you've made. You needn't recite or repeat the factual or procedural background. We have all of that, and we'll have questions for you. Each side of the V has 15 minutes in those cases where more than one attorney is arguing on either side of the V. Please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. The second case that we have one case that has requested to be taken out of order due to some travel commitments. We don't have all counsel present for that case at the present time. If we do fill out that the counsel for that case, we will take that case out of order, but otherwise we will presumably progress in order. The second case on our list for hearing is case number 2023-P534. This is a case involving the termination of parental rights. I'll just remind everyone that all of our cases are public hearings. That is particularly true in this day where we are able to broadcast and live stream and make available for viewing in an archived fashion on our YouTube channel the argument. So please, in the cases like this one that is impounded, refrain from reference to any of the impounded material, mother, father, child, etc. You may begin.
Thank you. Good morning, Your Honors. May it please the Court, I'm Jeremy Robin. I represent the father in this case. We have here a young father who was 21 at the time of trial, and he did something wrong, something very wrong. He had relations with a mother who was a minor, who was 14 at the time. He was so afraid of what the potential criminal consequences could be of what he did that he did not connect with the DCF and engage in services when the case was brought in.
How old was he when the mother became pregnant?
He was 21 when the child was born. He didn't do the things that he needed to do to be a fit parent. He didn't ignore the DCF. He did connect with them. He said on one occasion he wanted to have his lawyer present, but the reality is he didn't engage in the services he very much needed to engage in order to prove that he was a fit parent initially. But what matters here, I believe, is that he did ultimately engage in the services he needed to engage in. He established paternity. He went to the probate court he completed the paperwork that he needed to complete in the juvenile court to establish himself as the father. He completed a father's nurturing program to develop important parenting skills that he needed. He attended a foster care review. He signed releases so that the DCF could have access to his providers.
So could I ask you, because the judge's findings, I believe it's around 69 to 72, to his credit, Dad says he was, at least at the time of trial, not fit to care for the child. But then he said he would need to wait at least a year, putting that in quotes, to obtain custody. So these cases are always tricky. How do you balance that with the child's right to have stability and permanency?
Well, so that is obviously the ultimate question. And all I can say is that he is the father, and he did engage in the services. And we see a lot of cases that come in where a parent has a significant issue that brings the case in, whether it's mental health, whether it's substance abuse, whether it's domestic violence. The question then becomes, what does the parent do after the case comes in? And if they do what they need to do, then it could be an extreme instance of substance abuse or an extreme instance of any of these other issues. And that's what this father did here, ultimately.
So I know he says he thought she was of age. There is certainly some record evidence that mom is developmentally disabled and functions at the level of a 9 or 10-year-old. That's harder to square with him thinking at 20 that she was 17 or 18. So could you help me with that?
Well, so I think it has to be acknowledged that he made a mistake.
Well, it's more than a mistake. This was criminal conduct. This was statutory rape, and not simply statutory rape based on age. There was a predatory element to it based on the developmental disabilities that Justice Blake has alluded to.
Correct.
Let's not minimize the severity of the conduct.
Correct. There are also instances, to give an example, when a parent has committed a criminal act, a different criminal act, has committed domestic violence, and a case comes in.
In this instance, the criminal act gave rise to the conception of the child that's involved here.
Right. Right.
It seems to me that that's different.
There's no way of getting around that. That happened, and then the only thing he could control at that point is what does he do ultimately as a young dad to prove that he potentially could be fit at some point in the future. And he did get started, and acknowledgement number 2 is that he took a while to get started. And I think the explanation for that, not the justification for it, but the explanation is he was scared, right? He's a young person. He's facing potential criminal charges. He didn't respond the way he needed to, but he did. He ultimately did engage in what he needed to engage in.
Let's talk about his suggestions for placement, right? Because it was his mom and his grandma, or his grandma and great-grandma? I think it was grandmother and great-grandmother.
Okay.
So at least as to the grandmother, my understanding was although she filed for guardianship, she didn't show at the hearing. Is that, you're not, I know you say some things are clearly erroneous, but that's not a clearly erroneous finding, is it?
No, I don't believe that is, no.
Okay, that was at finding 71.
Okay.
What else did he put forward? So if paternal grandmother didn't appear, what about paternal great-grandmother? What did we know about her?
I'm sorry, I'm not really understanding the question.
In terms of, I understood this as somewhat of, don't terminate my rights, but if you do, I have a competing plan to the department's plan. It may not have been necessarily briefed in that succinct a term, but I'm trying to think about if he's young, he's just trying to figure it out, he needs more time. His suggestion, place the child with my family, and then I can sort of learn how to be a dad. I'm trying to understand why his 2 proposed placements were eliminated. At least as to the paternal grandmother, my understanding is one of the arguments is that she didn't show at the guardianship hearing, and also that she sort of harbored the mom and dad when it became known that they had had a sexual relationship. I don't have a lot here about the paternal great-grandmother, who was the second placement option that he proposed, so I'm trying to figure that out.
Candidly, I don't have an answer to that
Okay.
right now. I'm sorry.
And father had some mental health issues of his own, right?
So it was referenced in the findings. I don't think that was the issue that the trial judge focused on, but yes, there was some reference to him having some mental health issues. I wouldn't say they were significant from what I read, though.
So, I mean, it's not necessarily ever any one shortcoming, but you look at the circumstances taken as a whole to assess fitness. And here we have someone who didn't engage, well, I mean, it starts with the rape in a what I've described as a predatory framework, mental health issues, and the absence of a demonstrably suitable temporary custodial arrangement, failure to engage in services for an extended period of time in the young child's life.
Correct. But again, positive piece here is he did engage, and when he did engage, he engaged completely, I would say. He engaged in counseling, he established paternity.
Just to be clear, I mean, you know, he's still a very young man, and he can have children in the future. And I think we would all encourage that he did engage at some point. The question, though, and encourage him to continue. I mean, you're right, that makes this a little different, or a lot different from our other cases. But then there was still this issue that he needed at least a year. But I do want to make sure, to the extent he's watching, that he understands that it's good that he engaged, and that is to be encouraged. The question for us, though, more is, you know, this balance and this predicting of when he might be fit and ready to take custody of the child. It seems like it's uncontested from your point of view that he needed at least a year. Am I right about that?
That's what he said.
Well, It's uncontested that he needed some time, that he's not fit right now, and thus we're only challenging the termination piece. And along with that, I think, is our contention that he wasn't really given enough of a chance to prove that he could be a fit parent at some point in the not-so-distant future, which is paraphrasing the standard here, what the standard is. So he did have visits, and he was only given one visit a month, 3 total visits. How much bonding could really be accomplished in that period of time? But he was appropriate, and he brought a bag for the child with the child's name on it, and the child was more comfortable with him. So he was starting to do the things that a parent needs to do. What more are we asking him to do?
At what point was it that he expressed a desire to have a second child with the mother?
So I do remember seeing that.
She attained majority at that point?
I'm not sure of the answer to that.
Kind of an important question, isn't it?
I can get that answer for you, though.
We can look it up.
Okay. I also want to make mention, were you done with that line of questioning? Sorry. There were some troubling pieces to the judge's conducting of this trial. In fairness, obviously, we're all, no one's a machine, judge is not a machine, but there were some elements of potential bias which I wanted to bring to the court's attention.
So as a preliminary matter, the department argues the father waived any issue about the judge's conduct. What do you say to that?
Well, I think it would fall into the category of something that was pervasive throughout the trial, and therefore, and since it is a fundamental right to have a fair trial, I think it should be, I should have an opportunity to raise it.
I mean, the source of the concerns that the father voices about the judge's comments during the trial seem to be the judge's assessment or evaluation of the evidence of the father's shortcomings. Clearly, the father's entitled to a fair trial, but he's not entitled to a trial that is devoid of consideration of the evidentiary matters that come forward during the trial and the adverse consequences that may flow from those.
Agreed.
There's no suggestion that the judge was reacting to materials extraneous to the evidence in the trial itself, is there?
That's correct. That's correct.
All right.
However, while it certainly is relevant to consider the father's conduct here, the extent to which, in my view, the judge was consumed with this, and the examples are plenary, and they're cited in my brief. In 2 obvious examples to me was when he queried child's counsel and sort of asked her to function in more of a best interest type calculus, which is not the function of child's counsel. And there was mention of a criminal referral. There was badgering of the father and reminders of the conduct that he committed. And I think it went a little bit beyond what a fair arbiter.
Well, the judge appears to have exhibited some level of outrage at the father's underlying criminal conduct.
Agreed.
And you're saying that that's improper?
If it were just that would be proper. But again, it carried over, and it went a bit further than that. Obviously, that's an important factor to consider for any trier of fact, but the manner in which he continued to question and continued to sort of rehabilitate the department's witnesses without opening questions to the other lawyers, among many other examples. So I flag that as a concern. But the larger point I want to make is that there was a real possibility that this father could be fit at a time in the future. And that is, to paraphrase, I believe, the standard here when it comes to termination. I don't have any further.
So can I ask you a little bit more about that last argument? My review of the transcript suggests this judge was pretty involved, maybe more so than he should have been. But then we have to get to the issue of bias and prejudice. And I think about our Norbert case, where I think there were in excess of maybe 1,000 questions or interruptions that the trial judge interposed during the trial, and we still affirmed.
Right.
to me, this judge's conduct, it raised an eyebrow, but it didn't get to that 1,000 benchmark. So where does this case fall on the continuum if Norbert is our guiding light?
I've read Norbert, I'm familiar with it. I think the question is does it feel as if the father got a fair trial? And I realize that's a very vague and loaded type of question. But, I mean, I can understand both sides of it, but, and I'm not saying a judge shouldn't be impacted emotionally by facts of a case. That's a hard thing, I'm sure. I think he went too far, and I'll just leave it there. He didn't ask 1,000 questions, but he did other things that raised eyebrows when I read it. Thank you. Thank you.
Thank you. We will hear from counsel for the department.
Good morning. Good morning, Your Honors. William Cuddle for the Department of Children and Families. Judge Green, we're going to split our time 10 minutes, 5 minutes. Could you please let me know when I...
Title, I think the timer's wrong.
Let's reset the timer to 10 minutes, please.
Sorry about that.
Just,
Your fault.
okay, we're good to go on the timer?
We're good to
You
go.
want to let us know, want us to let you know when it's 2 minutes left?
Yeah, that'd be fine.
Sure.
2 minutes. We're asking the court to affirm the trial court's decision. I know you've read the briefs and the findings. I just want to point out a couple of important points that I think are good to mention.
Mr. Cuddle, this is Judge Blake. Could we start maybe where we left off with Father's counsel on the question? This judge was particularly active, and I'll put that word in quotes.
Yes.
When Father was on the stand and other witnesses, and I know what we said in Norbert. Why is this the same as Norbert, or why is it different than Norbert, I guess?
Well, I've been trying to come up with the phrase to describe my reading of the transcript as well, and I have come up with calling it, I believe the judge actively managed the trial. He actively managed the attorneys. But he wasn't biased, and the father certainly got a fair trial, because if you read the transcript, as I point out in my brief, the judge did interject from time to time, especially around the department's efforts with the father and what tasks he was or was not completing. But every time he interjected and interrupted, he would stop and he would always go back to let whatever attorney it was, and he interrupted all of the attorneys, not just father's attorney. He'd always let the attorneys go back and finish their examinations.
But he did try to, I guess, rephrase or recharacterize child's counsel's role from substituted judgment to best interest.
Well, first of all, that's closing argument. That wasn't evidence. I read that, and when I first read it, I was taken aback. As I read it more, this judge, and it's just to back up, I think you would agree that we're reading a transcript. We're not in the courtroom. I think the Norbert case talks about the tone of the voices in the courtroom. We don't really know how it sounded, but I do agree that the judge was very vigilant about the position the child's attorney was taking. But if you read on towards the end, when he says, "Okay, I want to write this down," he sounded like he was trying to take notes and understand what the position was, and acknowledge that she was substituting a judgment for the child. I didn't read it as trying to convince her otherwise. But at the end of the day, that wasn't evidence before the court at all. The other points that the father brings up in his brief about the bias issue, the judge was very careful, maybe too careful, in making sure the father understood his Fifth Amendment rights. If you remember at the beginning, the hearing, it was supposed to be the first day of trial, but it wasn't able to go forward. The judge was very careful and took a lot of time to remind the father that he didn't have to testify, that the testimony in a civil case can be used against him in a criminal case. He also asked the department to make sure they filed what they need to file with the district attorney's office, which had been done earlier in the case.
Well, but there's a difference between asking the department if they've made a referral to the district attorney versus what he did here, right? Which is, didn't he order them to do it?
I don't know if he ordered it, but he certainly sounded strong in his statement to them, Your Honor. I don't want to put words. I don't know exactly if he ordered it. I don't think it was an official order. But
Whether it was an
he did
order or
direct
not,
them.
it was a fairly firm thumb
Yes, it
on the
was.
scale.
Absolutely, it was. I can't second guess what the judge said or didn't say. But it's important to point out in this case, if you look at the findings and the conclusions of law, they're all based on father's actions during the case or inactions, what the court found. Every single finding is supported by a record cite, either to an exhibit or to testimony. There's very few references even to the incident between the father and the mother. He focused on father's indifference in meeting with the department. It took him 18 months to finally come forward to start working on the case. This child was almost 2 years old. The court did acknowledge that he made some efforts, but he didn't make the efforts that he needed to, and he certainly didn't, according to the judge and his findings, he wasn't able to make any progress. He took a parenting course in March. This trial started in June, several months after this point. This child was growing up without her parents, and father was not making the good decisions. I mean, he didn't make good decisions about taking his medicine. He used marijuana instead of taking his medicine. He was going to some therapy. The court could not tell because when father signed his release, it was in April of 2022, and the department worker tried to reach the therapist, couldn't do it. But the court, based on all the other statements that father had made earlier, didn't find him credible that he was going every week for therapy. He didn't have a plan for his child. Everything was speculation. He wanted to live with the child's great-grandmother, his grandmother. It got confusing with all the different terms.
You know, to answer Judge Blake's question from earlier, did the judge consider the great-grandmother, and why was she not an appropriate plan?
He did consider her because she never expressed an interest throughout the whole case in stepping forward to take care of the child. She was asked at the beginning of the case, as was the mother, and the great-grandmother said that she did not want to be involved with the case. Father never presented the great-grandmother during the case for the department to go and view her home. The child has no connection with the grandmother or the great-grandmother. Father had no plan. Father was trying to
There was some evidence in the record that when the father stayed over with the mother, that her mother wanted rent. Do you know how much the rent was?
I don't, Your Honor. I read that too, and I don't know any more about that than you do. I don't know. I don't know. But I know that, actually, Judge Green, before I forget, your question to my brother was asking when father was expressing an interest in a continued relationship with the mother, and that was in February of 2021. That's in the findings.
So the mother still would have been underage?
Yes, she would have been. So it's hard to focus on the actual facts of the case and not get caught up with the sexual relationship issue. But the court did a very good job of doing that here. And that's where there's no bias. Father got to put on his case. He called himself, his grandmother, his mother, and his great-grandmother or his grandmother. He admitted 8 exhibits into evidence. He had a fair trial.
Is the pre-adoptive home not kinship placement?
It's not kinship placement.
You're at about 2 minutes.
Does the panel have any other questions for me? If not, I'll rest on the department's brief. Thank you very much.
Thank you, Mr. Cuttle. For the child?
Good morning, members of the panel. May it please the court. My name is Michelle Lucier, and I represent the appellee child in this case, who is now 3.5 years old. We're asking the court to affirm the lower court's decision terminating the father's parental rights, as that is in her best interest.
Can I ask you, in your brief, I think it's at page 34, you suggest that the questioning by the judge, if error, was harmless error. Are you conceding error or no?
I'm not conceding error, Your Honor, but if it is determined by this court that the judge took an active role that was perhaps perceived as being unfair or biased, that it was harmless error. Your Honor, basically, the findings from the court, judge had a lot of questions around the statutory rape, brought up that quite a bit through the trial. That's pretty much acknowledged. But his findings did not really rest on that alone. His findings rested more on the fact that the father lacked judgment rather than engaged in criminal conduct. I would also like to point out to the court that there was a question, I believe, about the judge instructing the department to file or make a DA referral, basically. That had already been done back in August of 2019. So again, I would say that's harmless error. That had already.
Where did that lead?
Excuse me, Your Honor?
Where did that lead? Has the father been prosecuted?
I'm not aware that the father has been prosecuted.
Well, did the judge overstep and I'm quoting now, that I'm going to ask the Department of Children and Families to make a referral to the district attorney's office. Should he just have inquired whether they did it? I think the father is saying, well, that showed bias, that he took that extra step.
I think it's somewhat similar to the extra step that was taken by the judge in Norbert, where he had actually filed a 51A, and that was still deemed harmless error. So I would say that's similar. And again, the fact is that that 51A or DA referral had already been in the works. It had been in the process. And I believe there was some testimony from one of the social workers that the reason why it hadn't proceeded forward, the prosecution, was because of the mental status of the mother, and that they were going to be interviewing her that week.
So the father argues that the findings are sometimes conflicting. He specifically says the court discredited that father was in therapy, but then asserts the department remain concerned that despite obtaining counseling, father had unaddressed mental health diagnoses. Are the findings conflicting?
I did not see that as conflicting. I read that, and what I believe what was being said was that father said that he was in counseling. The department wasn't able to determine whether or not he was in counseling. The social worker had made 3 telephone calls and was unable to determine whether or not he was in counseling. So, of course, the department still had remaining concerns about whether or not his mental health issues were being addressed. And if there are no further questions.
Well, I wondered what your take was on, he's saying that there was some sarcasm from the judge that I could print a certificate in minutes, and then I don't remember at this point if it was you, the child, or the department, but somebody argued back, well, it was the social worker that was on the stand, and so the sarcasm wasn't addressed to the father, but it was like you didn't do your job of actually contacting the provider.
Exactly. Similar to the judge's concerns in Norbert, I think, about the department's differing goals. Again, yes. So in that exchange, I believe the social worker had said that she had had a release from the father, but, and I'm paraphrasing, but that she had not been able to verify whether or not father completed that Nurturing Fathers program. And so I think he was aiming that more at the social worker. Well, I could print up a certificate in 5 minutes if you gave me the chance. Meaning, why was that not verified? Why did you not make that call?
If there are no further questions, I see that your time has come to an end. Thank you all.
Thank you.
I'm advised that we have all counsel for the case I alluded to earlier, case number 2022 P1229. So we will take that case out of order. This is another case involving the termination of parental rights. It is impounded, and I will again remind counsel to refrain from referring to any of the impounded material. In particular, in this case, there is a rather significant injury to the child, and we need not get into the graphic details, except we don't have child's counsel?
Attorney Parker.
I thought we had all counsel. I was told that she had checked in, but let's hold for just a moment. All right, well, I'm sorry. We will then proceed instead with our third case, and hopefully if child's counsel returns, we can take it next. Instead, we will proceed with case number 2023 P179. This is a case involving a 209A protective order. This case is also partially impounded, so please refrain from referring to any of the impounded material.
Good morning, Your Honors, and may it please the Court. My name is Tiffany Bentley, and I represent the defendant in the underlying 209A proceeding. Appellant in the matter now before this Court, I will refer to him during my argument as either defendant or father. Your Honors, this is a case where the plaintiff mother has misused and
So
abused.
before you get into the details of the case, I have to ask you about your brief. To me, you misled us about what the statute says. I know you say you've put the entire statute in the appendix, which you're required to do, but as to whether or not a district court judge has the authority to enter a custody order, you left out the important piece of the statute that says if there is a prior or pending custody order. I know you, and I know that you don't mislead the court, so I want to give you the opportunity to clean this up.
Thank you, Your Honor. And it certainly was never my intent nor my colleagues' intent to mislead this court, nor to miscite or misquote the statute.
You're not suggesting that a district court judge has no authority to enter a custody order on a 209A, are you?
No, Your Honor, except where there are prior orders already entered in the probate and family court.
That's the piece that didn't make it into the brief.
But it is part of the record, Your Honor, because orders had already entered, and both counsel...
There are the orders in this record. I understand that there were prior proceedings, or pending proceedings in the probate and family court, but those were initiated after the custody order entered in this case with the original one-year order.
After the first order, correct, Your Honor. However, by the time of the extension hearing, orders in the probate and family court had already entered.
Where is the reference in the record to those orders?
It was represented by both counsel and acknowledged by both counsel in their representations at the hearing.
Well, reference to the transcript or the colloquy between the judge and counsel at the hearing does not, to my eyes, reflect the existence of an outstanding order. I'm looking at page, and this is the page from your brief, page 56. And it says, so this is the judge, so custody is with the mother. It is as of now, Your Honor, yes. But that would have been the case as a result of the order entered with the original one-year order.
And the probate and family court docket that starts at Record Appendix 100 does not show us the entry of any temporary custody order. I see the appointment of a GAL, I see the appointment of a privileged GAL, I see a request to enter a stipulation that was denied, but I don't see any underlying probate and family court, either custody stipulation or order from Judge Black.
It's on the same day that the guardian ad litem was appointed, Your Honor. Orders were entered on the plaintiff's amended motion for temporary orders. And while I recognize that the underlying pleadings are not before the court and were not presented to the district court.
Nor is the existence of those orders on our record.
I'm sorry, Your Honor?
Nor is the existence of those orders apparent on our record.
But it is part of the public record, Your Honor, with the docket that was accessible to the district court. And my reading of the transcript shows that both counsel were acknowledging that the orders had entered by that point and everything was being addressed in the probate and family court.
The day the GAL was appointed, it says that there is a joint motion to incorporate stipulation into temporary order. Let's even assume that that was on custody. The very next entry says stipulation in all capitals, not allowed.
Respectfully, Your Honor, the orders that I'm referencing are on the page prior to that in the record.
Okay, so which docket entry
I'm
on the
looking
probate
at
court?
docket entry 17 was the GAL appointment of Patricia
that.
Brady. Immediately below that, docket entry 23 is an order on plaintiff's amended motion for temporary orders and for
Is that an
appointment of a
order?
GAL.
To appoint the GAL.
It's an order on plaintiff's amended motion for temporary orders, Your Honor.
But it doesn't say what that order does.
And I acknowledge that that is unclear, but that taken together with representations of both counsel at the
Where's the
extension
representation of counsel?
hearing. The representation of counsel is in the colloquy between counsel and the judge, acknowledging that the custody matters were being addressed in the probate and family court as they should be,
Well, no.
was the district court
I
judge's
take it
commentary.
you're relying on page 56 where Mr. Henchy says something and then the judge says it's being handled through the probate and family court, and then Mr. Henchy says, yes, Your Honor, and the court says, as it should be. Now, what the "it" is a totally different question, but I take it that's what you're relying on?
That's correct, Your Honor.
Right, but that's talking about a motion for visitation. It's been denied to this point. That does not constitute a representation of counsel to the judge at that hearing that there were outstanding effective orders on custody entered in the probate and family court.
That is my reading of the record, Your Honor, and
It's
again,
not
it
my
was
reading
certainly-
of the record, and there's nothing in the record that says that.
I understand that, Your Honor. I do want to reiterate that it was never my intention or that of my colleague to mislead this court.
No, but it's a jurisdictional argument that is unsupported by the record.
I disagree, Your Honor, for the reasons I've stated, but I understand that Your Honor is making a different interpretation of the record, and that certainly is your province. I'll also note that that is but one of the arguments raised in our brief with respect to this order lacking any objective basis for being entered in the first
I apologize,
place.
Chief, but this was not an OBO order, right? She did not apply on behalf of.
That's correct, Your Honor. And
So to the extent the child is on the order, and I'm using that term very loosely, that is the check boxes of custody, do not contact, stay away.
that's correct, Your Honor. That's exactly correct. And it is my position that the allegations that were made here were not made out of an objective, reasonable fear of imminent serious physical harm to mother, but instead were made as part of divorce positioning. And because of this filing at the outset of the party separation and divorce, which has cast a shadow over the case as a whole, my client has not seen his daughter in 2 years now. The allegations that were made by mother are objectively shocking. However, even if true, my position is that they were not sufficient to support a 209A order under the standard applicable to such orders, either at the time of the initial entry in 2021 and most certainly not at the time of the extension 1 year ago. And that's the order that we're seeking.
In this case, it's not just her word, although her word is enough, but he wrote this text message to his friend about what happens when his daughter turns 18 and if she's attractive. And does he deny that he wrote that message?
I don't know, Your Honor. I don't know about the text messages. It's not, I have not seen them myself nor discussed that particular message with my client. But what I will say is that, yes, if that message was sent, it is disturbing, but it does not support the entry of a 209A order in favor of mother, meeting the standard that mother was placed in fear of imminent serious physical harm.
So what do we do? He also seems to admit that he said if she continued on, that she would need to involve the police. So what do we, I mean, again, that's then not just her word, because he's acknowledging seemingly that he said it. And so while he hadn't heard her at that point, the implication she needed to involve the police, could the judge draw the conclusion that meant she was in risk of physical harm?
I don't think that's a reasonable inference, Your Honor. First, my reading of the transcript from the initial hearing was that my client did not recall making that statement. Mother's interpretation was that it meant that he would get physical with her if she refused to allow the child to go with him. But based on the history of the relationship, I don't believe that that's a reasonable inference. And with that being the only real testimony about a fear of imminent serious physical harm, it's insufficient here to meet the standard for entry of a 209A order. I'll also mention, Your Honor,
Our case law say at this point, the review that he was entitled to under the ex parte order, he basically has had already, so we can't review that. We are really only reviewing the November 15, 2022 order. Is that right?
that's correct. And
So let's take everything about the child out of the equation. His acknowledgement that he shared sexual videos of his soon-to-be ex-wife with others without her consent, is that insufficient in and of itself for the issuance of a 209A to show imminent fear of reasonable harm?
well, first, Your Honor, he has not acknowledged disseminating any videos without his wife's consent. He is defending vigorously those criminal allegations. His position is that all of the photographs and videos at question were taken with her permission and disseminated with her permission, as she has already acknowledged that more than half of those that she presented to the district court were, in fact, consensual. So that is
It's not for us to evaluate, right? The judge
absolutely, Your Honor.
has the prerogative to resolve those contested issues of fact.
Absolutely, yes, Your Honor. However, my position as a matter of law is that if it is true that he sent nude photographs, took or sent nude photographs without her consent, that's not the standard for a 209A restraining order.
Would it be would she be entitled to a 258E harassment order if it was more than 3 videos?
Potentially, Your Honor, but that's not what's before this court nor before the
I'm just
district
trying to
court.
explore the context of your argument.
Potentially, Your Honor. I will also note on that point that part of the pending criminal proceedings include a no-contact order between the parties. So in the context and the totality of the circumstances that were present at the time of the extension hearing, again, back out the allegations about the child, because that certainly cannot form the basis of entering or extending an order on behalf of the mother. Take out the photographs, because that similarly cannot be the basis for entry or extension of an abuse prevention order. What we're left with here are 2 things: an allegation that there had been a violation of the abuse prevention order. That allegation was dismissed in the district court. It was not appealed. It is dismissed. That is not an issue. At the time of the extension hearing, there was no discussion about any alleged fear of imminent serious physical harm.
Just on representation of counsel, though?
It was on
Was
representation
that
of
by
counsel.
agreement of counsel? Because we don't have, for example, her under oath saying, "I'm still afraid," right?
Correct, Your Honor. That's correct.
Is it correct that the DCF fair hearing decision was not before the judge below?
It was certainly referenced, Your Honor, and it seems
Right,
to...
but the actual decision was not before the judge.
I was not trial counsel. It was my understanding, reviewing the transcript, that it was heavily discussed and was presented to the judge. Mr. Henchy represents that it was not and that he had never actually seen it. I was not there, Your Honor. However, I will reference that if Mr. Henchy had never seen it before it was apparent in the record appendix here, he certainly made representations about its contents to the district court. So I'm not sure what the timeline there was in terms of...
Representations that appear in the transcript appear to be inconsistent with the report itself.
I'm sorry, Your Honor.
I said the representations made in at the hearing, at least according to the transcript, appear to be inconsistent with the content of the report itself.
I agree with that as to Mr. Henchy's representations of the content of the report, Your Honor. My client's counsel correctly reported that the fair hearing report resulted in the the substantiated finding being reversed on substantive grounds, not merely procedural. This wasn't just about the department's failure to contact my client during the initial investigation. It was about the wholesale lack of any corroboration for the allegations that were being made.
So what is your closest case on the question of there has been a substantial change in circumstance to warrant a different result on the 209A extension? Either factually or procedurally, what's your closest case?
What I'm struck with, Your Honor, at both the time of the initial issuance and at the extension hearing was both trial court judges recognizing what a close call this was. So when I take that and I look at, for example, the Constance C. versus Raymond R. case, where the trial court similarly acknowledged that it was a close call as to the issuance, the facts here don't even come close to that case, and that case even was a close call. There was the defendant appearing at the victim's home multiple times, inundating her with text messages, incessant phone calls, multiple social media contacts, and that he became enraged when she enlisted the help of his family members to calm him down. In that case, it seems the factor that pushed in favor of issuing the order was the defendant's threat of self-harm, which the judge found was part of an escalated aggressiveness directed at the plaintiff. That's not here. There is very little, if any, evidence on the record here of any aggression directed at the plaintiff whatsoever.
Did he contest that he broke some things in the house during arguments?
He denies having broken anything in the house, Your Honor, and that was part of his cross-examination at the time of the initial hearing. So at most, what we have is some arguing, right, common as a marriage is breaking down. Perhaps he slammed his hand on the table on occasion. We don't have any past history of physical violence, nor an overt threat of physical violence. And it's my position that what wife has put before the court, in particular her focus on the photographs and on the child, show just how little else there is here. Her
I don't want
references...
you to get into the substantive question, and I can request an updated docket from the probate court, but how close is this to being resolved in the probate court?
My understanding, Your Honor, is that the reason that visitation has thus far
I
been
just want to
denied
know, do you have a trial date? Do you have a pretrial date?
the GAL investigation is still pending.
Okay, thank you.
Thank you, Your Honors.
Good morning, and may it please the court. Attorney Ian Henchy on behalf of the plaintiff appellee A.S. in this matter, who I will try to refer to as the plaintiff or the appellee.
I'm going to give you a hard time as well.
Of course.
Because I have two lawyers with great reputations, and I'm gobsmacked at these briefs. The fair hearing was not overturned on procedural grounds.
Agreed, Your
It
Honor.
was substantive.
Yes,
But you told the district court judge it was procedural.
I was wrong, Your Honor.
Clean it up.
Yes, so as I mentioned in my brief, the first time I saw that document was when I received it in the record appendix. Without revealing anything privileged or confidential, I'm certain the court can infer how I gleaned that information.
How do you make a representation to the court in a hearing where it matters
Yes,
about a report that you haven't laid eyes on?
that's a completely fair question, Your Honor, and that was the best information I had at the time, and it was wrong. It was reversed substantively.
But those representations matter.
Yes.
If you didn't know, if you hadn't seen the report, how in the world do you stand before a judge and make a representation about what it says?
Agreed. So that was my best understanding at the time, Your Honor. The divorce docket, or the whole case, is impounded. So not
But in
having-
those circumstances, isn't it incumbent on you to say, I'm sorry, Your Honor, I'm not in a position to tell you?
I think that's right, Your Honor, and I think that's something that absolutely will be presented on the 15th when we're back in Salem District Court, and I'll certainly clean up the fact that it was reversed substantively. It wasn't a procedural reversal. To address some of the other points, I see this in kind of three distinct parts. So there's the order as to the mother, there's the stay away, no contact as to the daughter, and then I think there's the custody issue that the court inquired about a bit. The order as to the mother, the trial court judge's determination to extend that order in no way fell outside the range of reasonable alternatives, given the representations that were presented at the 22 hearing, viewed in light of the initial allegations in the affidavit and the testimony back in 21. So that testimony and the initial affidavit consisted of an allegation that the husband had been verbally and emotionally, though not physically abusive for most of the relationship, that he would become angry, make threats, slam things around the house, break things. And then there was the issue of the dissemination of the sexually explicit photographs and videos. Working backwards, I think the dissemination and taking of those photographs and videos does not, as the appellant pointed out, constitute abuse per the meaning of 209A Section 1. What it is more ongoing litigation between the parties likely to engender further hostility under IMPOUNDED versus Aslan.
So I would agree with you 100% if you
Yes.
can anchor it to the abuse between the parties. Take the child piece out for a moment.
Sure.
What is your best evidence in the record of your client's fear of imminent harm?
So I think the best evidence in the record, Your Honor, is unrelated to actually the photographs and the videos. I think there was testimony at the 21 hearing and in her affidavit, or just at the 21 hearing, about if the husband were not allowed to take the daughter to see the parents, the wife would need to get the police involved. And there's testimony in the record appendix that states that she perceived that as a threat of physical harm.
To her?
Yes, Your Honor. And there was reference to, in the initial hearing, prior allegations of domestic violence. So I think viewing the totality of those circumstances, the threats, breaking things around the house, though not physically abusing her, and then the need to get the police involved statement demonstrated.
At the second extension hearing, right, because you had the ex parte, then you had the 1 year, now we're at the second 1 year. What is the standard at that point? What does the district court judge have to find at that stage of the proceedings?
Sure. So it's, the SJC, Your Honor, has said it's essentially a new showing. That doesn't mean the defendant can challenge the underlying basis of the initial order, but it is essentially a new showing by a preponderance of the evidence, viewing the totality of the circumstances in light of that initial order. So the argument that I was presenting at the 22 hearing was essentially that the allegations with respect to the mother had gained support in that the husband was charged with 35 counts each of photographing an unsuspecting nude person and then disseminating in the intervening year following a 3-day clerk's hearing in Peabody. And again, not abuse per the meaning of 209A Section 1, but more ongoing litigation likely to engender hostility between the
Look,
parties.
a contested divorce custody case is ongoing litigation,
Always,
right? I think
yes.
we would all be able to agree to that.
Yes.
So again, anchor her fear, her new showing. What's the new showing? That he's been charged?
So it's not just that he's been charged, Your Honor. What I essentially said was it's the same fear that she had at the initial hearing, and I know 209A Section 3 says the absence of abuse is not
Correct.
a reason to vacate the order. So there was also an allegation, and this was procedurally a little complicated because there was a motion to dismiss allowed on that 209A Section 7 violation.
Was that for the bow and arrow?
It was not that, Your Honor. It was magazines that had been left behind at the house. So he was charged with a 209A violation, and then Judge McNeil dismissed that, but it was kind of confusing to me at the time. It was on for status the day after our abuse prevention order hearing. So it was...
Dismissed prior to arraignment?
No, Your Honor, no. So it was pending. There was a De Benedetto motion filed, and then that was allowed. I'd like to shift to, if I could, the stay away, no contact as to the daughter.
Just before we shift.
Yes.
We do keep getting these cases, not just yours, where there's just representations of counsel. So,
Yes.
I mean, I would think that the judge could draw credibility determinations just based on the demeanor of the parties, like if the husband were, snorting or rolling his eyes or whatever. But I mean, what do we do with that? Because we don't have a credibility determination. The judge didn't actually take testimony. So what position are we in? Are we in as good a position as the judge, even though we can't see the parties?
I think that's a really good question, Your Honor. And My answer would be the Vitoni v. Claremont case that I did not cite in my brief at footnote 4 says so long as there's not an objection of counsel, these hearings can proceed on representation. I think the trial court judge is always in the best position to determine credibility, even if it's just proceeding on representation.
What was the case that you cited? I didn't hear you.
Oh, I'm probably pronouncing this wrong. Vitoni v. Claremont, or Vitone, V-I-T-T-O-N-E. Footnote 4, there's kind of a lengthy discussion of exactly that issue of can this proceed just on representation, or do we need evidence from the parties? I would also point out there, in the record appendix, page 59, I sort of kicked it to the court on how the court wanted to proceed. So I said, I'm aware the defendant is not going to be testifying, happy to proceed on representation, or if the court would prefer to hear from the wife, we could do that, but there are some new developments I'd like to discuss either way. The court then inquired, I think properly under that Vitoni case, as to how defendant's counsel wanted to proceed. He said, what's your pleasure, just argument, or point is there was no objection to that. So I think proceeding on representation was okay, where there was no objection in this case. If there are no more questions on that piece, I do want to just address the stay away, no contact with the daughter, and then certainly the custody piece was my biggest kind of issue with the appellant's brief. As the court noted, this wasn't an order that was filed on behalf of the minor child. Having said that, counsel correctly cited the Smith v. Joyce case for the proposition that there still needs to be independent support if there's a stay away, no contact as to the child. And I think there was maybe some confusion over the basis of that, because the wife's initial affidavit said me and the daughter have a fear for our physical safety, right? But then what was alleged was sexual abuse of the daughter. So I think that was a showing under 209A1C versus solely a 1B reasonable fear of imminent serious physical harm showing. And there is a case, it's the Yana Y versus Sylvester S case, 97 Mass Appeals Court 184, that notes where the plaintiff alleges the defendant forced her to engage in sexual acts against her will, or if there's physical abuse, there's no need to then show a reasonable fear of imminent serious physical harm on top of that.
Isn't that, in your case, that would be as to the mom?
Yes, Your Honor. And
It would
yes.
only be as to the daughter if it was an OBO restraining order.
I agree, Your Honor. All I can say is where the Smith v. Joyce case says there does need to be some kind of separate support. I know it's not an OBO order, and I pointed that out in my principal brief.
No, you did.
Yes. So there was not an order between the daughter and the husband, but there was still a stay away, no contact. So I would just say that the support for that is that kind of 1C showing, even though it wasn't an OBO order. So that was the independent support for at least the stay away, no contact as to the daughter. There did not need to be a showing that she was or remained in reasonable fear of imminent physical harm, especially where there wasn't, as Your Honor is saying, an order, mom, OBO, daughter, v. husband. I'd like to use some time.
Sorry, I'm just a
Yes.
little confused because there was no. I'm not as fluent in the acronym, but I understand that there was no request for an order on behalf of the daughter, and yet you're saying that because there was evidence that would have supported an order had one been requested, it was appropriate for the judge to issue one.
Not quite what I meant, Your Honor, and I may not have phrased it too well.
No, you didn't say that. Those are my words, placing what you did say into a box that corresponds to the posture of the case.
Understood, Your Honor. So I think in the Smith v. Joyce case, there also was not an order, I think, between the child and the husband. And I think the SJC reversed and said, well, there was no support to issue a stay away, no contact whatsoever as to the husband.
So you're suggesting that reference, that they reversed not on the lack of authority, but on the lack of support for an order, assuming that there was authority.
And I don't think there was authority to sort of sua sponte issue an order as to the daughter against the husband, Your Honor. I think it was just, there needs to be something. If you're going to order a husband,
yeah, but even if there is something.
Yes.
But there's no request for it. I'm having a little bit of difficulty understanding how it is that a judge issues an order in favor of a non-party.
Sure. So it was simply the stay away, no contact, Your Honor. It wasn't a separate, a 209A.
No, I understand, but,
Okay.
but it is an order,
It is, absolutely.
stay away, no contact.
Yes.
In favor of a non-party.
And my point isn't that the judge could have issued an order, because that wasn't before the trial court at any point, meaning a 209A order, sorry. But he can issue that stay away, no contact if there's support for it per the Smith v. Joyce case.
Go ahead.
Okay. Regarding the custody issue, because this was hotly contested in the briefs, my best case on this, I think, is the Quilla Q versus Matt M case. There were maybe three separate arguments. One, the judge needed to make written findings, which is absolutely not supported by a plain reading of 209A Section 3D that only applies to cases in probate and family court where there needs to be written findings, and that's the SG versus AK slip opinion, unpublished, that I cited and attached to my brief. The other issue was in the principal brief, there was a blatant miscitation of the statute that said where there is a pending probate and family court action, such as a divorce, the district court either can't issue any custody order or it has to be limited to 30 days. That is blatantly miscites the statute, as I said, and is incorrect. And I would point to that Quilla Q case at footnote 6. That provision having to do with, an order issued in Superior District or the BMC court departments may include any relief available, provided, however, upon issuing an order, the other courts have to transmit a copy of the order if there's a pending custody or support order. I think there's a conflation, especially in the reply brief, which tried to remedy this, of the denial of a request for visitation with a custody order. Those are very different things. Visitation is, as the appellant I think correctly would point out, solely in the province of the probate and family court. It says right on the front page of every 209A, visitation can only be ordered by the probate and family court. But I think what that section of the statute contemplates is inconsistent or conflicting orders. So a situation where maybe the husband has custody, the wife goes to get a 209A, and the husband's custody is stripped by the emergency custody provision on the 209A. And I think there's support for that in footnote 6 of Quilla Q, where it discusses conflicting orders. There's no conflict between the denial of visitation, twice in the probate and family court, and the emergency custody provision of a 209A order. So that was the issue I had with that, and that's the reason, it wasn't a request I made lightly or flippantly. That was the reason I requested under Avery versus Steele attorney's fees, because I believe that forces this court to go back and double-check every site, lest it be misled, and that threatens judicial integrity. So, the last thing I would say is...
Before we get to that, she says that there was temporary orders in the probate and family court, and she points to Record Appendix 103, docket entry 23. What do you say to that?
Here's what I would say to that, Your Honor. I don't see that on the docket. It wasn't before the court that there was any kind of custody order, so I don't know what position that leaves the trial court judge in to consider that where it's not presented to the court. And candidly, I don't think they exist. I know that's a bit outside the record, but I don't believe there was any custody order other than the emergency custody provision on the 209A abuse prevention order.
All right. I see that your time has come to an end. That concludes the argument in this case. And I also see that we now have all counsel in the case that I previously alluded to, case number 20. Where is my sheet here? Case number 2022 P1229. This is a case involving the termination of parental rights. And again, the case is impounded. And counsel is admonished not to refer to names of the parties or to get into the details of the physical injury suffered by the child. We will take a brief recess, by the way, after the conclusion of the argument in this case, before continuing with the remaining two cases on the list. Okay, you may begin. Wait a minute, I'm sorry. before you begin. Are we dividing time? This should be 15 minutes on the clock. Should it not? Thank you.
Perfect. Good morning, Vice Justice Green and Justices Henry and Blake. My name is Dana Shenevert, and I represent the mother in this case. And she's asking this court to vacate the order that terminated her parental rights and that a plan of transition be entered so that we can transition her son back to her care and custody. Contrary to the lower court's assessment of mother, she did not have grievous shortcomings that rendered her unfit at the time of trial. The trial judge's finding of parental unfitness is primarily based upon mother's initial reluctance to accept that her fiancé, the subject child's putative father, raped his own daughter. This is a child that DCF had reunified with father in the context of the open case that had been open for 3 years prior to this incident. And at the conclusion of trial, the trial judge, who was the same trial judge who heard this case and terminated my client's parental rights in this case, she found that DCF did not meet their burden in that case, and she ordered that the children be reunified with this father. 3 months after that case closed, or that trial ended, this horrific incident happened. No one saw this coming, not even DCF. So mother's initial reluctance to believe that this could happen or that this did happen is reasonable under the circumstances. DCF and Child's Counsel would like this court to believe that mother did not believe for a full 2 years and still didn't believe at the time of trial that putative father was responsible for this. But she believed it very early on in October, so far as immediately, actually. She separated.
What about her statement to the social worker that unless there was DNA evidence of his guilt, she would not believe he intentionally harmed the child?
There was an ongoing criminal case. The DA was involved.
She went to all his court appearances, visited him in prison.
She did, but those visits.
So how quick was her discovery?
That he was responsible?
Yes.
She moved out of their shared apartment within days.
Into the building where his parents lived?
His grandparents. So his grandparents had apparently a multifamily home. She had not been working at that time. She did not have the resources. This is what came out of the psychological evaluation.
That place was very nearby. His grandparents' place.
His grandparents' place was nearby.
Nearby where the mother and the children were living.
That could be true, Your Honor.
Well, it was true, but the concern, it seems to me, that underlies the ultimate order is that the mother did not take adequate measures either to recognize the danger or to protect the children.
At the time when she moved in with the paternal great-grandparents, she did not have the financial resources to find her own housing. DCF at that time, in September 2019, had helped her with a housing consultation. They were aware that she was she was seeking housing. She was not paying rent initially at the great-grandparents' home. When she got herself together and got a job and started working at Cumberland's, they began to charge her $300 rent, which was wicked cheap.
She had a choice to go to a shelter at that time, right? But she declined.
She did not. She had done research on the shelters. Actually, the social worker testified that at that time, mother was utilizing the services of the Elizabeth Friedman House, but there were wait lists, and the wait lists were lengthy. So instead
But let me ask you, because at findings 51 to 55, the judge discusses this and says that your client said she was on a housing waiting list, but she wouldn't sign releases, so the department couldn't confirm that that was true.
Well, the social worker, it was her initial social worker Miller, Chelsea Miller, testified that she was aware that mother was working with the Elizabeth Freeman Center and that she had helped mother complete these applications for Section 8 and low-income housing. Mother moved into that closet, that unsanctioned dwelling, out of desperation. The only, and I know the court did not credit her testimony that she did not know that father was going to be released to that premises, but just because the judge did not believe it does not constitute evidence of the opposite, meaning it doesn't mean that she actually did know that he was going to go there and that she intentionally went there to encounter him.
The department, though, says it's more than that. It's that she has this emotional dependency, so she gets attached to some partner in an intimate relationship very quickly and without thinking through the safety and appropriateness of her partners, certainly to children, perhaps to herself. So what do you say to that sort of, that they're sort of stepping back and taking this bigger picture view?
Sure. Big picture is that mother was working with a particular set of tools at the time that this incident occurred. And as she began to engage in therapy, and it sounds like even before she formally engaged in therapy, her thought processes around involvement with romantic partners had evolved such that she at the end, by the time of trial, she testified very clearly that, you know, her self-worth wasn't linked to any male partner, and she was able to do the things that she needed to do without the support of a male partner, such as, you know, find employment, which is what she did very well within 3 weeks of losing a job at a daycare because of the open DCF case to finding this job at Cumberland's, where she was very successful, had been promoted twice. She was able to locate and obtain her own market rent apartment. She wasn't on Section 8 when she moved out in May 2020. She was able to sustain that dwelling. Meanwhile, she's jumping through the hoops. She's not only jumping through the hoops, but she's benefiting from the services that DCF had recommended for her. She was delayed in getting into therapy to January 2021, but the record is clear that that was due to issues with insurance. She was on her father's insurance. She needed to switch over to Mass Health, and that's a process. That took a process for her. But even without insurance, she took her own initiative. Resilience is what Dr. Townley referred to it as. She was able to do private pay for her therapist and find one that she could afford, and meaningfully engaged in those services to the point where she could get to the place where she could acknowledge specifically that it was putative father who did this to his daughter. Initially, it's either his father, it was either paternal grandfather or father. She never said that father didn't do it. Her only representation, which is what came out in her psych evaluation, was that she did not have firsthand knowledge. She was not there. She knows that there are allegations floating out there of paternal grandfather also being a perpetrator. And this is what she was talking about, the DNA. There were DNA results pending for a long period of the case. I don't know if this court can take judicial notice of the docket of the Superior Court docket, but there were motions out there pending, motions to suppress this evidence, where the DNA results being everything, according to the record in this case, you know, his guilt hinged on the result of those DNA. So she was not saying, I'm not going to believe that this happened. I'm not going to believe. She didn't want to pin blame on him.
But in the meantime, she didn't separate either herself or the children meaningfully from him.
Well, I think, Justice Green, respectfully, the record would not support that contention. When she moved into the great-grandparents' home in August, the children were not in her custody. And she did testify, and if it's not clear from the testimony, there's a reasonable inference that this housing arrangement with the great-grandparents was temporary. This was a way for her to get on her feet so that she could move to a place, which she actually did. She moved from North Adams to Pittsfield, to her apartment where DCF had viewed the apartment and concluded that it was appropriate housing for the child. But at the time of trial,
so you're basically saying, okay, she may have been slow to recognize the father was the perpetrator, but because she got there by the time of trial, she was fit.
Well, it is current, and fitness is the standard, but it also, you know, the record reflects that she got there long before trial. Okay. You know, as early as September 2020.
Well, and I will say what I said in the other case, which is no matter what happens in this case, and obviously we have not conferenced on the case yet, you know, it's great that mother was doing things to work with the department and try to demonstrate her fitness.
It was. She was very cooperative through the whole process. There are a couple of cases that I'd like to bring to this court's attention that the department has brought also. So this case is akin to Isabel. In that case, let me grab my notes really quick. Sorry. To support the finding of unfitness, they needed evidence to support that mother couldn't protect her child from the father. That mother could not admit that that father, perpetrated assault against their child. But there's no evidence here that, mother acknowledged immediately that he was responsible. She was cooperative with DCF in the investigation. She created a safety plan that included how to make sure the child was safe. She moved out of the apartment that she shared before his release, and that's another one of the findings that the judge made, that she was involved with him for a full 3 months after this happened. That finding is clearly erroneous. There is evidence, the record reflects that she ended the relationship at the time of his arrest, which was late in July, and before he was released on bail, which was August 12th. So there were 3 weeks that she was in their shared apartment by necessity, I would say, and then she separated herself from him, and there's no evidence that she had anything more than passing, they were ships passing in the night, perhaps as she was going up to her apartment and he was, down on the stoop. But DCF did have that initial concern that she was still involved with him, but later that concern was dispelled after she moved.
Yes, so the department says that Isabel is different from this case, and they're saying that the determination here wasn't dependent just on mother's early support of the father, but really about this process that she had to go through, her lack of awareness and difficulty in accepting the facts surrounding the assault. So what do you say to that?
Well, I would disagree with DCF's position on that point because there was no support for father. Let's just put that out there initially. She was asking questions. She was seeking information about what happened, exactly what happened to the child. Regardless of whether she had questions about who did it, she took the actions necessary to protect this child. She took the child to the emergency or to the hospital immediately, which is something that I noticed was misstated in Child's brief. Child's brief states that she needed to be prodded to take the child to the hospital. That's not supported by the record. It's supported by the record that she came home, she saw the child in distress, she went to go get the paternal grandmother to go to the hospital with her, and from then they took the child to the hospital. This was all mother. She did not have to be prodded to do this.
But once she ends this relationship, she jumps right into a new relationship with, as I understand it, a guy that had drug charges, gun charges, breaking and entering charges. She wants to sort of parent with him if the child's returned to her, and then he moves in, has 7 or 8 jobs, and then is unfaithful and moves out. So in terms of her sort of track record with men and the stability of her relationships, doesn't that go to her judgment?
Sure. If there were any protective concerns with these subsequent relationships, DCF,
I don't know. To me, guns and drugs and B&Es would cause concern, no?
Well, I mean, they caused concern for DCF, and DCF looked into these issues and deemed him to be fine. They incorporated him into...
They said he was fine.
Well, they
put
incorporated...
him on a service action plan, and he didn't take parenting classes when she said he was going to co-parent with her.
They incorporated him into the case. He was cooperative with them. They found no protective concerns with him. The intimate relationship sure ended due to, infidelity is what the allegation is, but there's no evidence that he posed a threat, or DCF concluded actually that he would not pose a threat to the child. When that relationship ended, they went on with the case with mother. They found no protective concerns about, we'll call him JC.
What was the time frame between breaking up with father in this case and starting the relationship with what you're calling Mr. C? Do you have that?
don't have that
I can find
committed
it
to
in the record.
memory. But again, he had been a positive support for the mother. DCF found no protective concerns, and that was irrelevant at the time of trial. She had terminated that relationship. She remained single at the time of trial with this with the enlightenment that she did not need a partner.
Just briefly, because your time has expired, the child basically seems to be arguing that visitation will harm the child. So just preliminarily, has visitation been occurring?
Well, so we had that year-long hiatus, and the visit did occur, off the record, it occurred May 2023.
All right, and what's your response that visitation will harm the child?
I would respectfully disagree with that position. The court found in its findings that were issued a year after the case ended, that due to mother's flawless record of visitation with this child for weekly for 1 hour for the pendency of the case, that visitation was in this child's best interest. She was well within her discretion to make that determination, and there was no evidence on the record prior to that or during the pendency of the case that the visits were harmful to the child. The child benefited from the visits. Seeing mother weekly for 1 hour during the pandemic, in person and virtually, there were no issues with those visits whatsoever. And my time has expired. Thank you, Your Honors.
For the department?
Good morning, Your Honors. Lynn Murphy for the Department of Children and Families. I'll have 8 minutes, and my counsel for child will have the 7 remaining. The evidence here is very clear. The judge did not rely only on mother's hesitancy to terminate her relationship with father and her reluctance to understand the full situation that had occurred. There are 2 considerations here that the court found that she never accepted. She was never able to accept full culpability or even discuss the incident. She was not able to process that incident up to the time of trial, even in her testimony. So even though she did at points, the first 10 months, I think the evidence is unequivocal.
So the mother, though, says that's actually not a fair reading of the transcript because the transcript was walking her through a period of time. And so then at the end, when they said, do you believe he's culpable? The mother just said yes. And so it's not fair for us to look at these pieces. I just wondered what your response was to that.
Are you referring to the piece of her testimony? It wasn't fair.
Yeah, that it's because she was taken through sort of a chronology of her views but then the judge says, it wasn't until she was directly asked. And so the issue is, well, that was just the way the attorney structured the examination. You can't hold that against mother. I don't know whether that's accurate or not. I'm asking you to, that's what the assertion is. I'm asking you to tell us why it's wrong.
I would think that the evidence, particularly her testimony, shows that she had a very hard time answering questions. She could not, again, even describe the incident. And there were numerous questions and additional questions to get her to reluctantly. She was very, very guarded. And the judge was within their rights to look at that testimony, evaluate that testimony, and consider whether this is an individual who understood the severity of its action and could be able to assess risk in the future. And the fact that 2 years had gone by and the mother still struggled to process that incident, that was hugely important to the trial court, but that was not the only factor. We have 2 important factors. That was number 1. And the second one was her poor judgment in continuing to become enmeshed in romantic partnerships with very little information about these individuals. This continued right up until the time of trial. So we have an individual who has shown she cannot assess risk adequately for those 2 reasons, not only because of her reluctance to leave father, but because of her testimony showing, again, not able to process the incident.
Was there someone after Mr. C?
There was, yes. there was.
But on Mr. C, she says, well, the department gave him a service plan.
Right. Well, the department, the fact that we added him to the service plan didn't mean that we didn't have significant concerns. But when a parent says, well, I'm going to be, this person's in my life, and this is who I will be co-parenting, then the department did add him to the service plan and try to work with that. We're still trying to reunify. We were concurrent planning at that point.
So on the topic of concurrent planning, the ICPC was approved, and then the department chose not to go down that avenue, and you say in your brief that it was vague, the ICPC home study. Did you ask for more information, or did you just reject it out of hand?
I think what happened, and again, the record doesn't show a lot about that ICPC. I think probably what happened was once it was very vague and mother chose not to go back, that was what the department was hoping, or at least suggested, that mother, instead of living with that family, said, why don't you return to your mom, which was a great support for you at one point. And at that point, then the department would have definitely delved in there more so.
So mom had, at the point that the ICPC came back, mom had rejected the idea of going back to New York to live with mom?
That's correct. So at that point, once the department received the ICPC and it was very vague as to, for a placement, right, that's a very different decision the department has to make. Will we place with somebody versus reunification? Now, if mother had returned to her mother, then the reunification piece would have been much more detailed, and we would have been able to work. Again, if mother had been able to appreciate the severity of what had happened and shown movement or progress in assessing risk, and she moved in with the mother and she terminated this involvement.
Well, so she argued this morning, and I would think that she's thinking to herself, well, you can't really fault me for having bad judgment about the father or leaving the children with the father that day, because the department and a court just returned custody to him. So I take it your response is that's not why her rights were terminated?
No, absolutely not. I mean, at that point, the mother's father was involved with another mother. Her rights were terminated. The father, I don't believe he was ever a custodial parent of these other two children. The department continued to work to reunify father. We did believe he did services quite well. And actually, mom was also cooperating. So at that point, the department reunified. And
so you're not faulting her for that judgment. It's that everything that happened after he did the terrible thing.
Absolutely. Okay. Yes, absolutely. And again, I think the evidence is very strong. It took at least, she did not even get a new apartment till 10 months. So there really was very little movement. And when she started therapy, I think it was 6 months prior to trial, there was some, you did see some inklings of possible change in that regard, but it wasn't sufficient. And again, her testimony showed that whatever services she had done were not sufficient for her to develop the tools she needs to keep her child safe.
So I did want to raise a point of clarification, because you argued in your brief, that the mother had not remedied her deficits by the time of trial and the child had bonded with the foster parent. But to be clear, if the mother had remedied her deficits by the time of trial and was determined to be fit, then does the second piece of that, I mean, obviously it matters in the grand scheme, but legally, would a judge keep a child from a fit parent in that circumstance?
No, certainly not.
Okay.
Right. We need the unfitness, current unfitness, and then the next piece is termination. Does that serve the child's best interest? But we wouldn't have gotten there if mother had been fit, and the judge found in that regard. If there are no further questions, I see my time has almost expired. I'll ask you to affirm. Thank you very much.
Thank you. For the child.
Good morning, Your Honors. I am both the appellee in the termination and appellant on the visitation issue for the child. I just want to briefly review some of the facts on the termination issue. As of September 30th, the mother was not complying with her action plan, finding of facts 60. Finding of facts 38 and 37 and 40, the mother was encouraged to go live with her mother and was told it would not hinder reunification. And again, at finding of fact 89, the mother admitted being told that she could move in with her mother and that it would not be viewed negatively. So and I also want to point out finding of fact 102 that she was just diagnosed with adjustment disorder and disturbance of emotions, which resulted in impairment of her functions. And there were examples of this in the record that I would like to point out that were not emphasized by the judge, but one could see that there's, a pattern of using very poor judgment here. The mother did not initially bring the foster mother noted, the foster mother for the little girl who was ultimately the one raped, noted that she had visitation after she went to live with the father, noted that she had a sore in her leg that was not being addressed. She noted that the kid's dentist had said she had an infection. And then the mother failed to take the kid, and finally the foster mother took her, and she had ear infections externally and internally. So the poor judgment preceded this incident, and then it continued after this incident. In the court investigator's report, the maternal grandmother was already there because the mother had called her right after getting the text message. She was there at the time she came in, and the mother was reluctant to take.
You're talking about the paternal grandmother.
Paternal grandmother. The mother was reluctant to take the child to the hospital, and the grandmother said, "You've got to take her to the hospital." And then she really insisted that the grandmother go with her. But she didn't need the grandmother to go with her. She could have left the grandmother there to take care of the two younger children. So her impaired judgment is not just in relation to her denial of the father doing this. I mean, at first she says it was scratch. She tells the hospital it's a scratch. She was scratching herself. Then she tells them
We have limited time here. Why don't we talk a little bit about your argument on visitation?
Visitation issue. There is no case supporting post-adoption visitation when a child's placed when they're 2 months old. The court in adoption of Edgar discusses 7 limitations on ordering post-adoption visitation, and that adopted parents have the same rights toward their child as the biological parents do. This is an abuse of discretion. It's not appropriate when there isn't a long-standing, deep relationship between the parent and the child. No post-adoption visitation order was made until November 14th, 2022, 16 months after the end of the trial, which ended on July 16, 2021. During the several months after the goodbye visit on February 7th, 2022, the mother failed to make a motion or even call the department to ask for a visit. And that's in the supplemental appendix at page 65. There is no relationship to preserve, so that the order for visitation is an abuse of discretion as a matter of law. The mother's reliance on Alana is misplaced because Alana was 14 years old at the time of this SJC's decision and was 9 years old at the time she was removed, not 2 months old. Secondly, the SJC affirmed in Alana that there should be no visits, and it's because it's only appropriate if the child is worried about the loss of a relationship with a biological parent. The SJC and Alana also clarified that adoption of Rico was merely due to the facts in that case where the 9-year-old had been in 4 different foster homes and during the previous 6 years and had lost his placement with a pre-adopted family and had no placement or family and had a parent-child relationship with his father. So it was very unique to those facts. All these children are much older. Adoption of Flora involved a 4-year-old, like the child in this case is now. And the court said even when there was no identified pre-adoptive family for a 4-year-old, the court held that there is no suggestion here that the child needs such visitation to assist him as he negotiates at his young age.
Which case was that?
Adoption of Flora, 60 Mass App 334, 338, 2004. The torturous path from one family to another. The family he has known since birth is his foster family. It's only when the principal relationship in the child's life is with, and they have an emotional bond due to years, that visitation is appropriate. An adoption of Cecily, which involved a 2-year-old, like in the instant case, the court concluded there was no significant relationship despite monthly visitation. Well, here, the visitation hasn't been monthly since there were huge gaps. The bond must be significant in order to justify visitation. Zarina says, Zarissa, the purpose of visits is not to strengthen the bonds between the child and the biomother, but to assist the child as they negotiate the path from one family to another. And Terrence says, adoption of Terrence, it has to be based on emotional bonding and the actual personal relationship of the child to the bio parent, not the rights of the bio parent or the legal consequences of their natural relation.
Thank you. We've come to the end of your time and the end of the hearing in this matter, unless there are further questions, which I do not see. We will take a 15-minute recess and resume at what appears to be 1 o'clock on the clock, but the clock has not been updated in light of the end of daylight saving time. We continue our session with case number 2023 P611, Kimberly Cole versus the Boston Police Department.
Good afternoon, members of this panel. May it please the court. For the record, my name is Elizabeth T. I'm an assistant corporation counsel with the City of Boston, here today representing the Boston Police Department. There are two issues I want to address with the court. The first issue is whether a plaintiff claiming that they called the MCAD, the Massachusetts Commission Against Discrimination, plausibly suggests that that plaintiff satisfied the requirement of presentment under Chapter 258, Section 4.
Well, we had a preliminary question for you, which
Of
was
course.
your appeal timely? Because it looks like it was in 31 days rather than within 30.
So, Your Honor, my understanding from my predecessor counsel is that the appeal was from the motion to reconsider rather than the motion to
Let's
dismiss.
take that one step at a time.
Of course, Your Honor.
Because the 31 days that Judge Henry referred to does count the time after the action on the motion for reconsideration.
Understood, Your Honor.
But by my calculation, even that is a question, whether the reconsideration told the appeal period, because the original order entered on August 19th. The motion for reconsideration was served on September 12th, which is more than 10 days after the action on the motion, on the original, the entry of the original order.
Understood, Your Honor.
A motion for reconsideration filed outside 10 days is treated as a Rule 60B motion, not a Rule 59 motion, and doesn't operate to toll the appeal period. But even if we were to construe it as having been served within 10 days, the notice of appeal from the final action on the motion for reconsideration was filed 31 days, not 30 days, after the denial of the motion for reconsideration.
Understood, Your Honor.
So we get
And-
back to Judge Henry's question, is this timely?
So, Your Honor, it was my understanding from predecessor counsel that it was timely. I will not
Well,
I trust
okay,
the
why
panel.
don't you then
I trust the
explain,
panel's math.
why don't you explain to us,
Yes,
since predecessor counsel is not here,
of course, Your Honor.
if there is a basis for predecessor counsel's understanding that it was timely?
So, Your Honor,
The relevant dates, if we take the reconsideration, let's treat,
Of course.
just for sake of this conversation, let's treat the motion for reconsideration as having been effective to toll the appeal period, despite the concerns that I expressed earlier. The reconsideration was denied on October 17th.
Yes.
The notice of appeal was filed on November 17th.
Yes,
October has 31 days.
understood, Your Honor.
And November 17th was a Tuesday, so that we don't get into the first business day after a weekend.
Understood, Your Honor. And so, Your Honor, I can't, given the map that you've laid out, I do believe that the department made its best faith effort to have it be timely, but math is math, Your Honor, and I won't insult the court by...
So, I mean, there does appear to be a significant question about presentment on the merits, but we don't reach that if we don't reach the appeal, and it seems to me that it remains open, I suppose, to renew the motion to dismiss in the trial court, to point out the concerns that you've raised with us, which don't appear to have been engaged on reconsideration.
And, Your Honor, I'm more than happy to, after the court hears the argument today, I'm more than happy to further, given the court's concern about whether the appeal was filed in a timely manner, I'm more than happy to brief that issue. It's a valid concern of the court, and I want to make sure that the court has all of the information it needs. So if Your Honor would like, I can certainly further brief that issue.
I don't think we need further briefs here.
Understood, Your Honor.
All right.
I mean, unless you can demonstrate some sort of factual misunderstanding on our part about the timing.
We're basing it on the docket entry, so.
Right. No, I understand.
And so if I may, would you like an additional argument, or may I proceed with the substantive argument?
You have 10 minutes
I
left
do see
according to the
that.
clock. You needn't use all of them if there's not, if you run out of things to say.
Yes, Your Honor, I won't waste the court's time. I'll make sure that I go through this in a timely manner. So, Your Honor, I understand the court's concerns about whether the appeal was made in a timely manner, just assuming that the court would look at the substantive issues presented. The plaintiff, the appellee, filed a suit against the City of Boston Police Department in the fall of 2021, essentially arguing negligence on the behalf of the Boston Police Department. You'll see in the documents, in the exhibits that were provided, Your Honor, Your Honors, that there was a claim of negligence and other torts. That's both on the civil action cover sheet and the complaint itself. The lower court judge heard a motion to dismiss, and appellee made a claim that she called the MCAD a day or two after the alleged conduct. There is no evidence beyond just the statement of the appellee that that call was made. There's no information about the number that was used.
Why would that call be significant?
So, Your Honor, that call is the lower court's only basis for finding that presentment was made in this case under Chapter 258. So the language of the lower court judge, he said that this call to the MCAD plausibly suggests that presentment was made.
I thought the judge was saying that because she filed with the MCAD within, I think it's a 2-year period, and that got served on the city, that raised a question.
So, Your Honor, there was no, it's the city's position. There was never a letter filed with the MCAD. Your Honor, we'll see even in the exhibits provided, there are miscellaneous documents relating to a housing case involving a neighbor or some cat fees.
But you don't think there was a complaint filed with the MCAD?
There is no evidence. There is, in the facts presented, Your Honor, there is nothing showing that there was an actual complaint made with the MCAD. And in the transcript of the lower court motion to dismiss, plaintiff indicates, or the appellee indicates, that she made a call to the MCAD. It's within the language.
Do you have assuming for the moment that she did make a call or did file, really more particularly, she did file a complaint with the MCAD, and the MCAD sends a copy of the complaint to one of the people listed in the presentment statute, do you have a case that says that would not be sufficient to meet presentment?
So, Your Honor, I think that in a different situation, I don't think that that's the situation before this court. I do think that, as you indicated, there is that closed universe of people that would need to be served that alleged.
Well, I know, but if you had that case, it would, and we reached the merits, that seems like it would make for an easy decision.
I understand, Your Honor. And the city and the department's position was that we have never received such a letter. And so I understand that Your Honor's question is, if the city did receive that letter from the MCAD, would that constitute presentment? It's the department's position that no such letter was ever from the appellee herself or from the department.
Was this on a motion to dismiss? Wasn't this?
Pardon, Your Honor?
Wasn't this presentment issue raised on a motion to dismiss?
It was, and then.
So then we can't look at what the department says. We can only look at.
I understand, Your Honor. And so in the lower court judge's his ruling, he had indicated that this phone call plausibly suggests that the plaintiff made presentment. Deficiencies in the presentment, if any, should be addressed on a clearer record than is now before the court. And so predecessor counsel, given that he said on a clearer record, that's when the city filed that motion to reconsider to see if there was any additional information or argument or briefing, and it was denied without any additional context, Your Honor. So I understand that
you're saying beyond the scope of what was presented at the motion to dismiss, but the city did raise that argument that we have never received anything from the MCAD. And so I think for today's purposes, Your Honor, even if the city had received something, I would say that under the strict language of Chapter 258 that says, unless the claimant shall have first presented his claim in writing to the executive officer, and then there's this closed universe of individuals, mayor, city manager, town manager, et cetera. In this case, there is her own testimony in front of the lower court judge on which he based his ruling, Your Honor, that she made a phone call to the MCAD. The documents that you will see in the exhibit packet, there is no letter to the MCAD relating to this incident. There are letters relating to a housing dispute, about a landlord dispute. There is nothing in the facts pledge, Your Honor, that shows that that letter was ever sent. So I understand your argument that, you know, if that letter was sent, would that constitute presentment? I don't even think that we get to that point. I think that based on the testimony from the lower court judge, we're going off of whether this phone call was even made. So under 258, the city's position is that there was not even a letter, but even if there were, that it wasn't served upon the proper individuals. The MCAD is not one of those individuals in the closed universe of listed in 258. Your Honor, if I may, just noting my time, there is one additional issue I would just like to raise for the court, unless there are any further questions. I don't want to change gears if there's any remaining questions from the panel. So, Your Honor, just to make the record clear, when the court is making its decision, the lower court judge did, in a one-sentence claim, say, insofar as the complaint alleges for negligence, which we just addressed, in violation of civil rights, those claims remain for trial. I would note, just for the record, the city addressed this briefly in footnote 4 of its brief, that it's always been the city's position that the claims brought are claims of negligence and intentional torts. The intentional torts portion was allowed in that motion to dismiss that we were addressing. I just want to make clear for the record that it's the city's position that there is no pending civil rights claim. You'll see from the history of this case that it was removed to federal court. Judge Saris examined the case.
Is that part of this appeal at all?
So it was addressed in the footnote, Your Honor, and I just wanted to make sure that this was just explained a little bit more.
The footnote on the
city's brief for today. So,
right, but this was in the original order, not the order denying the motion to reconsider?
Yes, this was in the original order, and the city did address this in its motion to reconsider. So if Your Honor, if the court would indulge me, I can finish the argument. I understand that there are some limitations given where the appeal actually stemmed from, but I just wanted to make clear for the record, this statement of claims of violations of civil rights, it's the city's position that there are no such claims that would be remaining. There was a removal order to the federal court. Judge Saris reviewed everything and said, I don't see any federal civil rights claims, remanded the case. And I would just note for the record that there cannot be a state civil rights claim with a municipality as the defendant. So just for clarity of the record. And additionally, the statute of limitations, even if there was some sort of amendment for such a claim, the statute of limitations has since passed. So I just wanted to address that.
Are those issues in front of us on this appeal?
Pardon, Your Honor?
Are those issues in front of us on this appeal?
So, Your Honor, it was briefly raised by predecessor counsel. I just wanted to make sure, I know that primarily the issue is that issue of presentment, but I wanted to make sure that there is a complete record where this issue is addressed, even if the court doesn't ultimately consider it. I know that it was briefly mentioned, and just for the sake of a thorough record, Your Honor. I see that I have about 24 seconds left. I would, if there's any additional questions from the panel.
No, thank you.
Thank you so much.
For the plaintiff.
Good afternoon, Your Honor, Your Honor, Your
Step
Honor.
up to the podium and please speak into the microphone.
Okay, good afternoon, Your Honor. Good afternoon, good afternoon. My name is Kimberly Cole. I'm a pro se litigant.
You can grab
I
your
wish-
papers if they would be helpful to you, of course.
So if I, whom is pretty much as dumb as a bag of rocks when it comes to legal proceedings, I think the whole thing should just be stopped right now. It's so sad that Sarah had to leave the case because she's expecting her second baby and got a better job making more money, but she had 30 days and she took 31. And this lovely lady shows up and says, well, that's okay. One, the police should not have tear gassed me, causing me to fall in a pile of glass, causing me to need surgery, causing me to be so egregiously ill that I couldn't lift my head off a pillow, let alone file motions and get on into the courthouse and get into Mass Commission Against Discrimination and utilize my socioeconomic status, which to date leaves me with about $4 in my bank account. I think that Your Honor ought to consider that the Boston Police Department has a smorgasbord of lawyers available to, within 30 days, respond to all of Your Honors regarding this matter. It was Judge Thomas Francis McGuire at the Brockton Superior Court who refused the motions to dismiss. He did state in his ruling and under order on August 19th, 2022, that the motion to dismiss was only allowed in part as far as an intentional tort goes. However, insofar as the complaint alleged claims for negligence and violation of my civil rights, that those claims remained for trial. So had Boston Police Department's Ms. Attorney McAder, prior to leaving her esteemed position with the Boston Police, had found it important enough to complete her job in a timely fashion, then perhaps you would have a reason to tell me to go away, but you don't. I am a mother and grandmother. I have every right to stand on the State House steps with my children, advocating for the rights of our fellow human beings. We've been through the ringer in my family, and the last thing that I needed was my hand ripped wide open, which it is scarred for life, testimony that I have provided, as well as evidence from the thumbs up therapy that I was referred to by Dr. Christian Sampson after an extensive hand surgery, reveals that I have 43% usage of this hand. I have an 8-year-old grandson with autism. I want 100% usage of everything that I have in me for my family, my children, my grandchild. For the police, whose job is to protect and serve me, to tear gas me and drive up and down this beautiful city streets at about 70 miles an hour, punching people, screaming horrible obscenities. Let's go get these idiots. Let's go run them down. I was with myself, my daughter Julia Cole, Taylor Cummings, John Gammon, and Carol Pardino. I have known they're children to me, Your Honors. They're adults, actually. But to me, having had known them since they were little people, I call them the kids. So where I was there, and I utilized a handicap parking space because I had a pre-existing injury to my left leg, I safely assumed, and I brought it with me, it's big, I folded it up, that standing on my State House steps holding a giant peace sign was not going to end me up in a hospital with months of recovery time and still only 43% usage of my hand. So I agree with Judge Thomas Francis McGuire. It was an egregious violation of my civil rights, and there was, and I might not be smart enough to file it and win under an intentional tort, but the reason that the Geneva Accord says don't tear gas people is it can kill them. I could have died. We remember Victoria Snellgrove. I do. Don't fire that stuff at people holding peace signs on the State House steps. I have a family to go home to, and I realize police officers have a very difficult job. I am not belittling that, and I have great respect for them. I do not, however, respect those that willy-nilly fire a dangerous chemical agent into children and innocent parties attending a rally. So I ask the court to please dismiss the motion to dismiss in agreement with Judge Thomas Francis McGuire. I say Thomas Francis because my stepdad that just passed away, his name was Thomas Francis, so I feel like it's a little divine, little angelic energy. So sorry for being redundant. So I agree with Judge McGuire that the case should move forward, or they should simply offer me a settlement, because what I went through was horrific, painful, and 100% unnecessary. I could have walked the few yards back to my motor vehicle, me and the kids gone home, celebrating that we had utilized our First Amendment right to free speech on the very steps of that beautiful State House adorned with the lead paint gold cap. So, that being the case, I would ask you to please consider very seriously that a citizen that did absolutely nothing. I wasn't throwing bottles of urine. I wasn't throwing bricks. Again, I was holding a big, beautifully painted peace sign with all the names of the black kids that had been killed by cops on the back. It's right here in my bag. So to be standing there with these young people who I was so proud of, and we were there in a very peaceful manner, and to be standing there with them and then to feel my limbs starting to burn and my hands starting to burn, and the kids saying, well, why do I smell eggs? What's that awful smell? And then some woman come whipping over the hill, screaming at the top of her lungs, run for your lives. It was like, no disrespect to soldiers, but if you'd been out in front of the State House on May 31st, 2020, it was like being in a war zone. There was smoke everywhere. There were police flying up and down the street, careening around the corners, almost smashing into people. And as you can see, abusing them and abusing their power.
So the city is saying even if all of that is true, you had a certain amount of time
And
to
I did. That very night I got home, I called MCAD. They called them back the next morning because they weren't open. I had a pre-existing complaint on file with Mass Commission Against Discrimination. I did, in fact, inform Judge McGuire that it wasn't just a phone call to the Mass Commission Against Discrimination. There was a corresponding case number to that phone call, and then with the corresponding case number, there is follow-up. And as a person that has severe bilateral cataracts, who, because I couldn't bring my eyes with me today, a lovely gal named Caitlin who does all my reading for me, I can't go into my files. She tried so hard to highlight in yellow. Mom, please make sure you read the stuff I highlight in yellow, but I still can't see it. So I'm sort of winging it at this point, but you have before you what you have before you. I filed this case 916. The Boston police refused it multiple times. The process server for the Boston Process Server Division, John Johnson, said they're refusing to take it. I have tried 5 times to deliver it. So they were like, as far as I was concerned, you're not even good enough for us to hear your concern. That's what that said to me. But I still had surgery pending, and I still had therapy pending, and I have not been able to continue with therapy because I am not in a situation where I can be traveling town to town financially to obtain the care that I was requiring to get from 43% usage of my left hand back up to 100. So I would like to be able to care for myself in a manner that is conducive to wellness, and which is why I seek to be awarded the amount that I asked for. And I did make mention of it in my most recent filing before the court that the Boston Police Department were late in their response. And by now knowing that it's because Sarah got a better job making more money, that says to me that, again, she did not care enough about my case because she was leaving. So what did she care if it got in on time? So I just ask you to please allow this case to move forward or deny the very repetitive motion to dismiss that Boston Police just kept filing and filing, and Brockton kept saying no, and then for whatever reason, again, I'm not an attorney, it went up to the federal court, and I just kept responding, kept looking up what are these MGLs that are going to make sense in this case. I literally reached out to everyone I could reach out to with my limited financial resources to try and make heads or tails of this and try and get some justice for being assaulted and battered for absolutely nothing. So, thank you.
Any other questions?
And have a nice day. Do you have any questions? I'm so
Thank you.
sorry. I'm not very good at this.
Thank you. Thank you both.
Thank you. Have a nice day.
That brings us to the sixth and final case on our list for hearing today, case number 2022 P985, Mark W. Williamson versus TAMAR, BARLAM, and others.
Excuse me. Thank you.
Good afternoon, Chief Justice Green, justices of the panel. May it please the court, my name is Greg Assetto, and I represent Mark Williamson as the trustee of 902 Mass Ave Realty Trust. I wanted to start off where the trial court ended, which was the motion to dismiss. The motion, as we all are very familiar, the motion to dismiss standard is very clear in the law. It should be denied, whereas here the plaintiff's claim is supported by factual allegations that raise a right to relief above the speculative level based on the assumption that all allegations in the complaint are true. That's the well-worn Iannacino case that is cited constantly. All that is required at the plea...
Counsel, sometimes we like to just right-size the case by kind of lopping off things that we don't have to worry about. So here, there seems to be some allegation that the second buyer that wanted to open a Japanese Asian restaurant never actually approached the trustees to get clearance under this, the non-compete. So if that, do we know whether that is, do you agree that they never approached the trustees? I mean, can that just be separated off? Because if they never approached the trustees, that's not the defendant's fault.
I agree that I do believe that they did not approach. That was part of the motion to reconsider and additional evidence that came up after the motion to dismiss.
Okay.
But yeah, I believe that they did not proceed, understanding that they were not going to have the votes necessary to go forward from the trustee panel.
Right. So then the other thing I have a little concern about is when you look at the bylaw, it says it's agreed no business conducted in any of the units shall substantially compete, et cetera. But then it says that they acknowledge that the businesses existing at the time of the recording of the Declaration of Trust, which were the Mass Ave Diner and the Plow and Stars,
Yes.
do not violate this provision.
Yes.
So the challenge with the provision, though, is you could either say have businesses that don't compete, or the trustees can vote to allow businesses to compete, right?
Either no one believes that there's substantial competition with the existing
Right.
operations, or there has to be a vote of 4 out of 5 trustees, yes.
And so you could have substantial competition. So
Right.
when we look, for example, at the Atomic Bean, it could have been either one, right?
Well, in this case, in Atomic Bean, no one raised the allegation that it was substantial competition, and so the sale went forward.
I
And the
thought that
business-
was like the whole discussion.
No,
There was discussion about it, no?
No, there was never any discussion. None of the trustees ever raised that issue, that there was substantial competition. In fact, that's what Attorney Farkas says in his deposition transcript. That's part of the record, and that's also
Yes,
what I
why
believe.
can we rely on his deposition testimony? I mean, don't we start with the 4 corners of the document?
Well, yes, but I explained this was an unusual set of circumstances where the deposition of Attorney Farkas happened days before the motion to dismiss hearing. I highlighted to the court that I had testimony of Attorney Farkas that supported our position that the substantial competition was being misinterpreted and misapplied. We say intentionally, but whatever. I presented that to the judge. When the judge wholesale denied the motion to dismiss, we filed a motion to reconsider and act, because we did ask for the opportunity to amend the pleadings, and the judge did not allow it either way. We asked again, a second time, to allow us to amend the pleadings to add the allegations from Attorney Farkas, who was at the time and still is the attorney for the condominium trust. That motion was rejected. So the transcript is available because I wanted to point out to the trial court that we have testimony. We're not just fabricating this. We have testimony from the attorney, the objective attorney from the condominium association, that this provision was not meant to bar an entire category. And in fact, Attorney Farkas goes into detail about the process that was not implemented to challenge Atomic Bean, that operated a restaurant, a sit-down restaurant for breakfast and lunch for 12 years in that space in the condominium. So I offer that testimony, and I raise it with Your Honor because it shows that we could easily amend the complaint if necessary. I don't even think it should be necessary if all of the allegations in the complaint are taken as true, which they must be. I don't even think I need that allegation, but be that as it may, we are here. And so I would amend the complaint to add that Attorney Farkas testified that this provision means the following. And it's crucial because although Mr. Lucking says that this term, substantial competition, is commonly used in Massachusetts and is in the courts, if one looks at the cases, there's only 2 cases in Massachusetts that he cites to for this, and they're not substantial competition. One of them says substantial, one of them says similar or like. There's nowhere in the Commonwealth that there's a case that comes down to define the term substantial competition. There's no definition in the trust. There's no definition in any of the documents of the condominium association. So there is a...
I take it you're saying, it seems more like we're focusing on the Plow and Star. You're saying an Italian restaurant's completely different from an Irish restaurant, right? Is that
Correct, Judge.
even? And they seem to be saying, well, liquor license, liquor license, liquor license.
Right.
And I take it you think that's not the right comparison.
I don't believe that that's the standard now, that the standard is substantial competition. And just because they sell liquor, well, the Mass Ave Diner sells liquor as well, Judge, and no one raised that issue. That's in my briefing as well, that
At breakfast or lunch?
I'm sorry?
At breakfast or lunch?
I'm not really sure. But it's important to note, Judge, that, and this was not back in 2007, I believe it was within the last 5 or 6 years, they applied for a liquor license, and no one raised the issue of substantial competition. So there's some inconsistencies as to how this provision is being applied. And and we're talking about a motion to dismiss stage, so everything has to be interpreted, that I assert, as true for purposes at this stage. And I'm saying that it was not applied this way up until recently. And so
So you say, so David, you're saying, is on the potentially exposed to 93A liability because he's not a trustee. Is that right?
well, I say that both of them are, because just because the other individual, Barlam, is a trustee, does not shield him from liability.
Because you're saying, well, he really was acting in some ways as a trustee, but some ways he was acting in his own self-interest, and so just that
Correct.
title doesn't give him an umbrella.
Exactly. But I focused on David because there's no question that he's not a trustee. And again, all these allegations have to be interpreted in a light most favorable to me as true. And what I'm saying is that David interfered with this contract and I allege that he acted unfairly and deceptively in trade or commerce, and you brought up 93A, so I'll jump to that issue. There are cases, Judge, right on point that say we do not have to allege that the two parties engaged in direct commercial transactions. All we have to
This
prove.
seemed to just strike me as Anthony Pier 4 all over again. I mean, I don't remember the details, but that was the case that came to mind.
Which case, Judge?
Anthony's Pier 4.
Yes, and I cited to that case in my brief as well, Judge. In Anthony's Pier 4, there's the question of fact is generally the question of unfair and deceptive acts is a determination that's inappropriate for a motion to dismiss. That's what the court said in Anthony's Pier 4. Yet this case was dismissed on a motion. This count was dismissed on a motion to dismiss when I asserted the elements: unfair and deceptive act or practices in trade or commerce. And I don't. And under the Mallette case, Judge, I don't have to prove privity between the plaintiff and the defendants. I just have to prove that they're in commerce. And my client was trying to sell his business, sell his real estate. There was someone who wanted to buy it, and someone interfered with it. So that's the commerce that's going on here. It has nothing to do with the trust or the trustees' roles. They interfered in that transaction. And I attached as well the testimony of the two Willises, where they say they were intimidated, they were uncomfortable. David told them that you were paying
So
too
he
much.
says, oh, well, the Willises said that that David and the other fellow, Gabriel, I think, made a reasonable offer or reasonable counteroffer. So what do you say to that?
At this stage, I don't think it really matters. Everything that I assert in the complaint have to be taken as true, Judge. This is very unusual to have an entire case, a commercial transaction with very different counts, all being dismissed with prejudice, too. I mean, one thing if I could refile the case, but the trial court dismissed the entire case with prejudice, finding that there's not a plausible set of facts, given all the allegations in the complaint must be interpreted as true, that there's no set of facts that I could prevail on a motion to dismiss. I just don't.
Did you say you cited the Anthony's Pier 4 case? Because I can't find it. I know the case, I just didn't know where.
If I didn't cite it, I got it from reviewing the briefs. If I didn't cite it, then my brother cited it, Judge. So maybe it's not in my brief, but I know that I didn't do.
I don't think anybody cited it.
That was my
Well,
conclusion.
then I apologize. Maybe I got it from research that I was doing over the last few days from it. But the Anthony's Pier 4 case stands for that proposition. I apologize if it's not cited.
I mean, he had a right, didn't he? I don't remember the total details, but I thought he had some sort of right of approval, and then the issue was if he really misbehaved in exercising that right of approval.
I think that that's true, yes. I think that that's true, Judge. But the other area, the other counts that I wanted to focus on in my limited time that's left, Judge, is the declaratory judgment action. Now, Mr. Lucking emphasizes on this Buffalo Water case, he essentially says that unless you have other counts, the declaratory judgment must be dismissed. That's how he's interpreted Buffalo Water. And I've read that many times to try and understand where he's getting that interpretation from. I don't believe it stands for that. It stands for the proposition that that up until Buffalo Water, the courts could not dismiss DJ actions, period. That case says if there's not enough allegations in the DJ action to stand on its own, then it can be dismissed, but it does not have to be dismissed. And I submit to your honors.
I take it you're wanting a declaratory judgment as to the meaning of this non-compete provision?
Well, not just that, Judge. I listed in detail in the complaint exactly what legal issues that are the subject of a case or controversy, and that we need a declaration by the court as to the rights, obligations, and liabilities. And I listed them all in that section. I won't take up my time doing it, but I wanted to point out a couple of them. For instance, I wrote in detail whether the non-compete provision constitutes an unreasonable restraint on alienation on its face or as it was applied by the defendants. And that gets to this issue of what we were talking about before, Justice Henry, which is that the substantial competition. What does that term mean? Was it applied fairly to my client? I also detailed...
Your client, though, I mean, he seems to be arguing that he's being held up by these two, but it does seem like there's some room for maneuvering here, because he could go to the other units and really stick it to these two by selling to them at a higher price, and then they can take control over here. So it seems like your client actually could, or he could say, you want to, improperly gain control of this or properly gain control of this condominium trust, pay me a premium, and he could get these people to fight it out over him.
But important to note, Justice Henry, there's only 5 units, 3 of them are controlled by the defendants. So it's a vote, the way it was set up, as Chief Justice Green mentioned, it's a vote of 4 out of 5 if anyone raises the issue of potential substantial
Yeah,
competition.
we've seen,
So-
I know we've seen this case before, not him in particular, but any of these deals where somebody buys into a building and they're the minority owner. I know I've sat on one of these cases.
I have not found that case. I would be interested. I have researched time and time again. I have not found, it may not be.
I can assure you I was on that case. I
Well, I
think
don't
Judge
question
Uno
that.
might also have been on that case, but that could be me misremembering. But it was in Springfield, and it was somebody bought in knowing they bought in a minority, and your guy is in a similar situation. These deals never work out. I don't know why any attorney ever lets anybody buy into one of these situations.
Well, I wasn't the attorney at the time. This was in
Good for you.
2008.
Good.
But it was, so he did, Mr. Williamson did buy in after the condominium documents were enacted. But that's the point that suggests unfairness to my client, because he went there to open up a restaurant. It was never challenged as substantial competition. He relies on that. And then 12 years later, he tries to sell to someone else that wants to do a restaurant. And now all of a sudden he's hit with, you can't open a restaurant there.
So he's going to get up, and I think he even said in his brief, well, the restaurant your guy had was like a Starbucks. That's not like a sit-down, full-service kitchen. Totally different.
Again, Judge, at this stage, what my client asserts and what Mr. Clarizia and Attorney Farkas say has to be taken as true. And it was a sit-down restaurant, breakfast and lunch.
You could sit down and eat your smoothie and your muffin.
I'll tell you this, Judge, that
I'm being serious, right? So that's why.
it was more than muffins. It was
Okay.
sandwiches and soups, and it was a.
Okay.
It was a. I would say it was a breakfast and lunch place, probably the best way to describe it, with a focus on coffee, but they served other food. So was it a Starbucks? I don't think that that's a inappropriate analogy. Yeah, but at Starbucks, there's plenty of people that sit down and eat in there. Did they have a waitress waiting on them, which I guess is probably the next question? I think they had someone waiting on them at the tables, but you ordered at the counter, which is similar to Starbucks, I guess. But now we're kind of splitting hairs. But I would say, Your Honor, that Mr. Williamson's space is the largest space, has the most square footage of any of the 5 units. And him combined with Mr. Clarizia, they have a majority of square footage. So they control certain aspects of the condo association, but they don't control this vote because 3 out of 5, for the pub is owned by Mr. Barlam, and then the other 2 spaces are owned by some of the other defendants. So
One thing I was confused about, though, is so if there was some restaurant in your guy's unit that makes $1 gajillion, does that somehow benefit the condominium association?
Well, see, so that gets to the affidavit that was submitted early on in this case, which is part of the record from the broker, who said that, and he's an expert in this area, at least I would offer him as such, said that having a restaurant in the area that drives traffic to benefits all the other restaurants. And so that was part of the argument, that this is not going to harm Plow and Star. It's in fact going to enhance their visibility because there'll be more people in the area. If you come to eat at an Italian restaurant, you might go drink at the pub afterwards, or vice versa. And so that was the argument that was made, that it would enhance.
Right, or if your restaurant was super busy and the wait was long, people might say, F this, I'm going to go watch the
Yes.
Irish music right here.
And all this I could not raise because we never got to even a summary judgment stage.
Okay.
All right. Thank you.
Thank you.
Good afternoon. May it please the court. My name is James Lucking. I'm here on behalf of the 6 defendant appellees. I will refer to them as the defendants.
Motion to dismiss?
Motion to dismiss.
Actually,
I went back. I thought less about Anthony's Pier 4 when I read this case than I did about one of Justice Cass's classics, Kobayashi.
Okay.
And I'm sure you remember that case involving the proper construction interpretation of a non-compete involving a delicatessen.
It rings a bell, yes.
Well, if you haven't read it recently, I commend the footnotes in particular. That case was resolved after a jury trial into the scope and meaning of the non-compete. How are we to resolve a question whether a white tablecloth fine dining Italian restaurant is substantially similar to a bar that serves food and plays a plays music.
You don't have to. It's not the business of the courts to insert themselves as if they were a condo trustee or a board member of a corporation. That's not your job. It's not to micromanage the internal affairs of these organizations. It's either a business judgment rule or a reasonableness standard.
Wait a minute. The property owner who buys into a condominium that imposes restrictions is entitled to an assurance that the rights that they hold by virtue of that purchase are defined by the condominium documents, not by the whim of the association exercising business judgment. Isn't that true?
Well, they're entitled, the Noble v. Murphy case, which is my most important
familiar
case.
with it.
Yeah, my most important case. They stress that, I mean, this is a condominium use restriction.
Right.
Use restrictions
Which,
require.
of course, has to go, there's a distinction between what can go into the rules and regulations that can change over time and what has to be baked into the foundational documents if it's to be enforced against purchasers.
Correct. And this was in the bylaws. This wasn't a rule or regulation.
I understand it was in the bylaws, but the application and execution of that provision is not, it's based on whether a restaurant is substantially similar, not based on whether the other owners want to allow it to take place.
Well, that's correct. And Judge Salinger raised this point. I mean, so just to finish my thought, let's just say it's a reasonableness standard, because there is a little bit conflicting case law, but when it comes to, well, the use restriction itself, Noble v. Murphy, it's a reasonable standard. If it's reasonable, it can exist. If it's unreasonable, it can't. In terms of the application of the rule, the enactment of the rule, it also can be subject to a reasonableness standard. And Judge Salinger said, okay, suppose instead of an Italian restaurant, it was a hardware store. Could I, you know, what then? What would I do with your motion to dismiss? And I would say you would deny it, because it is absolutely unreasonable to say that a hardware store substantially competes with an Irish restaurant. It's ridiculous.
Are we looking at that in the light most favorable to Mr. Williamson?
Well, I think we can use our common sense and say, listen, is it absolutely I mean, what is the Plow and Stars? A full-service restaurant with a...
The question really is, if you have all this about what Judge Salinger said in the hearing, but what he says in ruling on your motion is, for the reasons stated in the defendant's initial and reply memoranda. That suggests to me that he applied the wrong standard. It wasn't taken in the light most favorable to Mr. Williamson.
Well, no, because our memoranda recognizes what the law is. It recognized what the law is. And there's a distinction between assertions of fact and assertions and conclusory allegations of intent, motive, and conspiracy.
Let me ask you this. Do you have another appellate case that resolves a question of the interpretation of a non-competition clause on a motion to dismiss?
On a motion to dismiss,
I would think that the question of the relative similarity or disparity between two separate business operations would ordinarily be a question that would require some factual development.
Well, I mean, we're in the privileged position right now where the record doesn't just include the complaint. Depositions were taken, and those have been included by Mr. Williamson.
Well, wait a minute. You're not suggesting that this was converted to a Rule 56 motion with the consent of the parties?
No, I'm not. The motion.
So, and I'm a little rusty on the detailed workings of this element of Rule 12, but I don't think that there's some sort of twilight hybrid of a Rule 12 motion that allows you to take into account a little bit of early discovery, but not a full record. Am I wrong on that? Is there something new in the way that Rule 12 motions are considered these days?
No, we take it based upon the allegations of the complaint, but it's the allegation. It's the allegations.
We're not in a privileged position at all. We're back in the traditional position of looking at the complaint.
Okay, but I think it's important to come back to what we're looking at. It's reasonable. Is there a reasonableness? I think a judge. I mean, a judge sitting on the bench can look at the allegations in the complaint and apply common sense and say, listen.
Without a developed factual record.
Well, with the factual record that's in the complaint. That's saying, listen, it's a full-service restaurant with full liquor license and table service. Same thing with the other one. I think, is it, for my clients to lose, it would have to be found that it is entirely unreasonable for these trustees to decide that it's
So there is no plausible basis to suggest that substantially similar would differentiate between an Irish pub and an Italian fine dining restaurant?
There's no plausible basis to suggest that it would be entirely unreasonable for a board of trustees to feel that a full-service restaurant substantially competes with another full-service restaurant when really we're talking about Irish versus Italian. I don't think ethnicity.
I'm not talking about the style of cuisine.
Oh, okay.
Or even the color of the beer. I'm talking about the tenor of the operation.
And there's a detailed description in the documents that the
complaint?
In the complaint, in the in the purchase and sale agreement that the plaintiff attached, the purchase and sale agreement, there is a detailed description in the purchase and sale as to what exactly the proposed restaurant by the Willises was going to be. And it includes these elements that we're talking about: full-service restaurant, full kitchen, waitstaff, full liquor license.
So let's say you're right on the 12B6. I'm troubled by the dismissal with prejudice without really ruling on the motion to amend, where under 15, isn't he entitled to one as a matter of right in the motion to dismiss?
No, absolutely not. Johnston v. Box. It's the Supreme Judicial Court case. It is directly on point. Johnston v. Box, that's the SJC, when a plaintiff files an opposition to a motion to dismiss, never files a motion to amend. No, there's no motion to amend in the record here. You don't have it because it wasn't filed.
I read it as being sort of an alternative ground if you're not going to dismiss.
It was slipped in at the end. It said, basically, we oppose it. They were put on notice as to the weaknesses of the complaint. We filed the motion to dismiss back in February. They had months and months. As a matter of right, they could have filed an amended complaint up until the point where judgment was entered. The Massachusetts rule is a little different than the federal rule. They chose not to. Instead, they opposed the motion to dismiss, slipped one line in at the end saying, hey, if we got it wrong, give us another chance. Johnston v. Box says, no, that's not enough. That's absolutely not enough. If you want a motion to, if you want an amended complaint, you got to do it. You have to, you're on notice. You have to tell us what we're proposing to amend, and then we can consider it. So that was never done. So there's absolutely, and this is an abuse of discretion standard. There was no abuse of discretion. It's on point. I think it's a slam dunk. And even if it weren't, again, what we're looking at, the one amendment that they tried to make was, oh, it's going to harm all the units, not my units. So therefore, the derivative claims stand. Well, that's not true. As we, this was discussed with Judge Salinger, and we provided the case law. Harm to all the units is not harm to the association. An association is a separate entity from one unit or even all the units. So the only proposed amendment would be futile anyways. But again, we don't even have to get there. It was not an abuse of discretion when they didn't even make an effort.
It's correct that there's no memorandum of decision. It's the handwritten notation on the motion.
Correct.
So I want to go back to the restaurants, though. So the Mass Ave Diner has a full kitchen and a liquor license, right? And so
Yes.
what's the difference?
Well,
Why
so first
are they
of all,
not?
it's important to recognize that when the bylaws were adopted and Article 5, Section 5 was adopted, I think it was referenced a little earlier, all existing businesses, it said, was recognized that they do not substantially compete with each other.
Okay,
So
but is that a basis to interpret that statement as exempting them from the restriction, or a statement that would be an interpretive guide?
I think it exempts them from. I think at the time they were saying, listen, even
what you're saying in answer to my question is that you are assuming that it would violate the restriction.
Oh, I think that's exactly why it was the language is put in there.
Well, another way of doing it is to illustrate that the language does not restrict or prohibit that degree of similarity. That the degree of similarity, in order to constitute a prohibited business, would have to be more dissimilar than those two.
I think either way, honestly,
because you've got a sandwich shop on the one hand and an Irish pub on the other hand, and those are not substantially similar.
I think that either way is fine. Honestly, I don't think it affects our case, because the restaurant being proposed by the Willises was, I mean, let's just focus on the Plow. It would certainly compete, substantially compete, with the Plow and Stars to a greater degree than a breakfast and lunch diner would.
Well, but one way to interpret this is to say that both of them have a full-service kitchen and both of them have a liquor license, although maybe the one liquor license came later, and that is not substantial competition. And then there's an inference, well, why is it not substantial competition? It's because either because Mass Ave Diner doesn't serve what I would call supper, or because the food is just very different. And so going back to the Japanese Asian food, I'm struggling to see how the Japanese Asian concept would compete with the Irish live music concept. If Emmett's here was talking about moving in, I could totally understand your concern. But Japanese Asian versus the Irish, that is harder to understand.
I mean, again, I think we're focusing on ethnicity and style.
We're focusing on
style of food, exactly. When
style
really, I mean,
of operation.
These restaurant owners, these are business people. They don't care what style of food, what the decor looks like. They're talking about full-service restaurants, full kitchen, waitstaff, table. People standing in front of their building, they have two choices. And again, the job of the court is not to substitute what you would do if you were a trustee. That's not your job. Is it reasonable? Is it reasonable that they would view this as a substantial threat, as a substantial competition? And just to get to your point on 93A, I know my time is winding down. When the Atomic Bean went in, which is a coffee shop, the deposition that the person who's going to open the Atomic Bean assured him that it was not going to have a grill, not going to have a kitchen, it was not going to serve hot breakfast. And that's, he said, okay, it's really just going to be a coffee shop, that we all know what that is. So that's why it never became an issue, because it wasn't going to substantially be. His fears were, and this never went to the board. And this is something that, I mean, there's no trustee decision at issue here. So there's nothing for the court even to really review. It's not as if the trustees decided that something and then this court has to review it. I mean, a lawsuit was launched when the Willises broke off negotiations. I mean, it's important to understand what the facts are. I know I'm running low on time, but again, the factual allegations here, the factual allegations, as opposed to just the allegations regarding intent, motive, and conspiracy, the factual allegations which aren't in dispute, this is remarkable. We actually agree on almost all the facts. It's the condo was formed in 2007, February. The bylaw was included. Mr. Williamson purchased his unit in September. He knew about the bylaws. The following year, the Atomic Bean Cafe came in. They benefited for 12 years. Unfortunately, in the pandemic, the cafe closed. Then he went to sell it to Mr. Williamson. Mr. Willis, they understood that it substantially competed. That's why it's in their purchase and sale agreement, that they have to get the assent. They knew it. And negotiations were open. They negotiated. My clients, David and Gabriel, engaged in good faith negotiations. They made a reasonable offer. And even after they made that reasonable offer, then the Willises continued to make demands, including, and this is in the record, the demand that Article 5, Section 5 be ripped out entirely. That's what they demanded. And of course, Mr. O'Malley and Mr. Barlam said, well, we can't do that. At that point, the Willises said, okay, we're out. And then they terminated the purchase and sale. Why they really did that, who knows? I don't know, but this is the fact.
But why is David Barlam in the middle of this when he's not a trustee?
Because he's a business owner. And this goes to 93A, where David Barlam is protected. He's a business owner. The fact that he's not a trustee, Office One Inc. is just a subset of internal disputes, intra-enterprise disputes are not subject to 93A. David Barlam was asserting his rights as a business owner. He was protected by this. This is still a condominium dispute. He's asserting his rights under the non-compete. And so, if Mr. Williamson's attacking him for doing that, then it's protected by the 93A. It's the internal affair. If it's not, if he's saying no, it has nothing to do with that, he's just a business owner, well then, we have the case here, LB Corporation v. Schweitzer, where just because you're two businesses and you don't like something that someone does, these were two businesses that were budding landowners. There has to be some interaction. There has to be. There has to be some interaction between, it's not just one businessman says, I don't like what that guy did, it negatively affects me.
I think we're going to have to leave it there.
Okay.
We're well over time. But that is an interesting case. Thank you both for your presentations. The case is submitted, and our argument session is at its end. We are adjourned. Thank you.
Thank you.